Yes.
May I please receive?
Hmm.
I humbly apologize for mentioning this DB matter, but on 2/3/2025, this honorable court have directed to fix the habeas corpus petition, which is WPC Criminal 325 on Friday today. But in the order, it is fixed on 11/4. There was some mistake in the order. Please,
Which matter? There were two matters, which one matter I've directed it to be fixed on 11/4. That is by, your matter. You mentioned the matter when we are sitting in the DB, second half.
okay, my lord.
You have got the records?
Yes, I have it.
Mention it for unlisted.
Okay, my lord. Hello, like.
Yeah, please, Your Lordship.
Hmm.
I'd like to mention item number 29 on behalf of my senior. Your Lordship, we are still waiting for further instruction.
What instruction?
Your Lordship, in the affidavit filed by the state respondent, there are certain allegations made by the administrations or the petitioners. And the main person.
When
who is
did they
the
file the affidavit? When did they file the affidavit?
Your Lordship, we received that affidavit on 16th of February, Lordship. And the
Do
main
one thing.
person
No,
who is to
the-
coordinate with us.
No, these hearing matters,
Yes, Your Lordship.
you mentioned when the hearing things, if you don't want to do it, no problem, okay? But don't, now let us not spoil our time with all these things. We'll take it up, we will adjourn if you don't want. Okay?
The motion, item number 1.
Yes, what are you challenging here?
Please, Lordship, here I'm seeking appointment on land ownership basis,
Owners.
and as well as I'm challenging the approval and appointment order private respondent number 6.
Of the respondent number,
6. Lordship, here,
which order you are referring to?
order approval order dated 17/1/2023,
Page,
page 28.
this is appointed under what provision?
Without any selection process nor advertisement. Was appointed illegally.
No selection proceedings.
Yes, Lord.
God bless your Lordship. Lordship, at this stage, late notice call.
Huh?
Late notice call, Lordship.
No, obviously notice will go because he's challenging after 2 years.
Lordship,
Why?
the petitioner father, who was serving as an MTS at GS Government High School, Niwoto Village. He was released from the service on 31/10/2019, and the petitioner was about to submit his application on land ownership. However, at that point of time,
How did your father get appointment?
on general category, and my grandfather, Dr. P. Niwoto TC, was the founder and chief of Niwoto Village, and he has donated land to the education department, measuring about 250 feet, 250 to 250 feet. That is 62,500 square feet.
So there the
And the SDO
district
civil
education office was situated? District education office is situated where?
Lordship,
Where was the, here the appointment is made out here. Now, if you are claiming on the basis that there is no advertisement, it is a different case.
yes, Lordship.
It cannot be non-consideration of the petitioner's application dated so-and-so under the so-and-so. Impugn approval of so-and-so and the impugn appointment order. So there is an oral agreement. So whether the verification process in
Yes,
terms with the notice.
the SDO civil, Newland and DO, SDO, on twice occasion made spot verification and has submitted a report to the principal director, to the DC, and to the commissioner skate. And they have clearly said that the petitioner father was not appointed on land ownership basis.
But this land was for also for a school.
Yes, government high school.
Now the appointment is made to the respondent number 6 where?
In the year 2023,
Where?
at government high school, Niwoto.
Huh?
Government high school, Niwoto village. As MTS, multi-tax.
Where is the impugn order? Page?
Order is at page 22 or 28.
This appointment is hereby appointed multitasking staff at GHS Nihoto.
Yes, Lord.
That is the place.
Yes.
Okay. So this is being done without any advertisement.
Advertise.
Chalo. We issue notice. issue notice, making it returnable on 21st of May, 22nd of May, 2025. Ms. So-and-so accepts notice on behalf of the respondent numbers 1, 2, 3, 4, and 5. Whose the extra copies of the writ petition be served upon her within 2 days. As regards the respondent number 6, the petitioner is directed to take steps by registered as well as usual within 2 days. First, the case of the petitioner in brief is that the petitioner's grandfather had donated a plot of land verbally, orally, to the district administration for
the-
setting up of
To the school education
was
department.
had donated, had orally donated, had donated a plot of land at measuring 62,500 square feet for the purpose of establishment of the government high school at Nihoto village. First, at the time of donating the said land, it is the case of the petitioner that there was an oral agreement between the parties that a grade 4 staff post would be allotted to the landowner in lieu of the allotment of the land, in lieu of the donation of the land. First of. Thereupon, the father of the petitioner was appointed on his merit and not on landowner basis. First, the petitioner thereupon submitted an application on 10/5/2023 seeking appointment on landowner basis. First, the respondent authorities, however, without considering the application of the petitioner, had appointed the respondent number 6 by an order dated 26 April 2023. He gave it earlier.
Lordship?
You gave it on 10/5.
Yes, Lord.
His appointment is on 26 April. Then
Only after I have submitted my application,
why did you wake up so late?
Lordship, in the year 2019, my father.
Wait, let us see what is your age.
However, in the year
34, then you were-
pandemic hit. During the time of pandemic, my father was released from the service. So,
It is the case of the petitioner that on 10/5/2023, he had submitted an application for consideration for being considered for appointment on landowner basis. However, that has not yet been considered. It is the further case of the petitioner that the respondent number 6 in the meantime was appointed by an order dated 26/4/2023 without following the due process. The respondents herein are directed to bring on record their stand by filing their affidavit on or before the next date. First, the maintainability of the writ petition is kept open, taking into account the delay in the maintainability of the writ petition insofar as a challenge to the notification to the order dated 26/4/2023 is kept open, taking into account there has been considerable delay in filing the instant petition.
And Lordship, I respectfully pray to make correction in the cost title of respondent number 3. Here, inadvertently, I have added SCERT, which may be strike off. The Principal Director, Department of School Education only, and not SCERT. My cost title, respondent number 3. I may be allowed to strike that SCERT.
The learned counsel, it becomes very difficult to do that if you don't file an application for that. The learned counsel appearing on behalf of the petitioner submits that the designation,
Yes.
if the designation
Yes.
The designation of the respondent number 3 has been inadvertently is incorrect, which he would like to make due correction. First, taking into account the above, leave is granted to the petitioner. Leave is granted to the petitioner to file a fresh memo of parties before the registry of this court during the course of the day. You file it today.
Yes, Lord.
First, on the basis of the fresh memo of parties so filed, the registry shall make necessary correction of the records in the make necessary correction of the cause title of the instant petition and also update the same in the CIS. You file it today.
Yes, Lord.
Obliged.
From the supplementary cost list for motion, item number 34.
Yes, what are you challenging?
Your Lordship, this matter pertains to consideration of the claim of the petitioner for the compensation of comprehensive personal accident cover under Pradhan Mantri Garib Kalyan Package insurance scheme for health workers fighting COVID-19 in respect of his late brother, Your Lordship. Your Lordship, during the onset of the global pandemic, the central government has formulated this policy on behalf of the frontline workers. The brother of the petitioner was an employee in the Department of Health and Family Welfare and was posted at Wokha. And in the year 2020, while he was detailed as a frontline worker, he passed away. And thereafter, the petitioner here applied for the compensation scheme.
Where?
Through the Department of Health and Family Welfare. And thereafter, on 21/7/2022, application was submitted through proper channel. And however, Your Lordship, only on 13 March 2024. The application was submitted on 21/7/2022. And on 13 March 2024, it was informed to the petitioner that a succession certificate and an affidavits were required before settling the claim of the petitioner. And
The succession certificate and the affidavit are required.
Yes.
Then
We got a succession certificate on 21/5/2024. And thereafter, the declaration by the mother and the wife of the late of the petitioner's late brother were submitted to the office on 21/5/2024. Thereafter, since there was no action on the part of the state respondents, a legal notice was served to them to forward the claim of the petitioner. And on 17/10/2024, the legal notice was forwarded. And thereafter, on 18/10/2024, the state respondents has replied that they have forwarded the claim of the petitioner. Thereafter, since even after then, the claim of the petitioner has not been settled, so the petitioner gave a legal notice to the respondent number 8, which is the insurance company. However, till date, there has been no movement. And
who is to pay you the money?
the respondent number 8,
Who is responding by it?
the insurance company, which is the assistant manager, New India Assurance Company Limited.
Now, why are you asking the assistant manager, New India Assurance Company Limited?
The communications are going through him only.
Now, are you not applying on the basis of a scheme by the government?
Yes, Your Worship.
So why the government is not going to pay? Not the government is going to get it reimbursed or indemnified by the insurance company. It's a different aspect of the matter.
Your Worship,
Let's see the scheme.
scheme is paragraph 6, sorry. Oh, that makes 6.
Page
Your Worship, just a moment, Your Worship. Page number 27A, Your Worship. This is the form of the insurance. Okay.
No,
Here,
this is
Your
by the
Worship,
government of India.
the documents 27.
Pradhan Mantri package so and so New India personal accident form to be completed by the claimant. Because all these communications are being issued by none of the communication is issued by the insurance company to you.
No, Your Worship. It
This
has
is-
been
this is-
done to the state respondents, Your Worship.
So it is the state respondent and this is to be paid by the central government.
Yes, Your Worship.
Then who is central government? Yes, Mr. Yangavati, you are there. Have you made the central government a party?
Yes, Your Worship. I responded number 1, Your Worship.
You have not been given a copy?
Lordship, always, till last year, he was my junior. We were in the same.
So what? My senior was Justice Gogoi. I appeared before him.
Yeah, I can copy. Copy.
See, the scheme is of the Pradhan Mantri Garib Kalyan package, insurance scheme for health workers fighting COVID-19.
No.
Now, this is a scheme of the government of India. The government of India is getting it sponsored or indemnified by the insurance company. But the fact that he is entitled to get the amount on the basis of fulfilling the criteria
Yes.
is the duty of the government of India to say, or if the implementing agency is the state has to reimburse the amount. How they get it from the insurance company is a different aspect to the matter. That is a different thing. The insurance company, the government has to put the pressure upon the insurance company to make the payment, isn't it?
Yes, sir.
Chalo. Issue notice making it returnable on 26th of May 2025. Mr. Yangavati, the learned CGSC, accepts notice on behalf of the respondent number 1. Full stop. Ms. So-and-so appearing on behalf, accepts notice on behalf of the respondent number 2, 3, 4, 5, 6, 7. Full stop. Taking into account that the respondent number 1 to 7 are duly represented, extra copies of the writ petition be served upon them by by Monday. Put the date, huh? As regards the respondent number 8, the petitioner is directed to take steps. Mr. Counsel, kindly wait. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that inadvertently the respondent number 8 have been mentioned as the respondent number 8 has been impleaded as the assistant manager of the New India Assurance Company Limited. He submits that the manner in which the respondent number 8 has been impleaded is incorrect, and he would therefore like to make necessary correction. He submits that the respondent number 8 ought to have been the New India Assurance Company Limited, represented by the assistant manager. Taking into account the above, leave is granted to the petitioner to file a fresh memo of parties within 2 days. The petitioner is further directed and fresh memo of parties before the registry of this court by Monday. The petitioner, the registry shall, on the basis of the fresh memo of parties so filed, shall make necessary correction in the cause title of the instant writ petition and also update the same in the CIS. Full stop. The petitioner is further directed to take steps upon the respondent number 8 by way of registered as well as usual. Full stop. The petitioner is the brother of one. What is his name? Bipinthung Lotha.
Bipinthung Lotha.
Lotha, who expired, who was a frontline worker,
Health worker.
frontline worker, and expired during the COVID pandemic. Full stop. It is the case of the petitioner that the government of India had announced a scheme being the Pradhan Mantri Garib Kalyan Package, insurance scheme for health workers fighting COVID-19. Taking into account the said scheme, the petitioner, who is the brother of the deceased, filed an application, submitted the claim application. The said claim application was being had submitted the claim application through the proper channel. Upon submission of the claim application, there has been various correspondences departmentally. After further verification, the petitioner was asked to submit the succession certificate as well as affidavits, wherein the other family members, apart from the legal heir / successor, do not have any issue with regard to the claim. The petitioner thereupon submitted the said affidavits as well as the succession certificate. Where is your succession certificate?
Financial one, Your Lordship.
Succession certificate.
Yes. Page 15.
In spite of submitting the succession certificate as far back as on 21/5/2024, the respondent authorities have not paid the dues to the petitioner, and it is under such circumstances the instant writ petition has been filed seeking appropriate redirection and order. The respondents herein are directed to bring on record their stand by filing their respective affidavits. Pendency of the instant writ petition shall not be a bar upon the respondents to release the amount if found due to the petitioner.
Pleasure.
You filed a fresh memo, party.
Yes, Lordship.
Because when you are making a company, you can't make the assistant manager, because you can't if I issue a writ to him, then he may say that I don't have money.
Yes, Lordship. That's a place.
For admission, item number 2.
Yes, Mr. Seki.
Please, Your Lordship. Your Lordship, this is a case where the petitioner there is very less remedy for the petitioner to even ask, because the service rule of the state does not support his case. But there were some practices in the past where similarly situated persons were also regularized. The only extraordinary circumstance here, which my Lord may kindly appreciate, is on 1st of April 2015, when he was on official duty. On duty, he was shot by a 303 rifle, Your Lordship, the pelvic bone. My Lord, after a few years of trying to cope with the duty, it became so hard for a person to continue with the normal duty. So he submitted a representation in 2020, requesting for regularization, like the similarly situated persons who were regularized earlier. But the same was not replied. It was not address, Your Lordship. So a writ petition was filed before the Dishonorable Court for consideration of the representation. After that, after the direction of the Dishonorable Court, the representation was rejected. So the petition was again filed before the Dishonorable Court, Your Lordship. If we go by the Himachal Pradesh rules for the home guards, even if it is voluntary in nature, Your Lordship, they have a provision to give, Your Lordship, compensation. In our service rule, there is no ground for compensation also for a home guard employee. And the new service rules of 2015 does not support regularization also, Your Lordship. It's a pathetic case where the petitioner has even approached the division bench to challenge the rule, but since the rule does not cover a voluntary person, the writ petition challenging the rules before the division bench was also dismissed last year, Your Lordship.
So you want that this court should direct regularizing the service of the petitioner
Lordship,
on the
considering
ground that
the
he had, while he was a casual employee, he suffered a injury
the gun wound, yes, Your Lordship.
on duty. What is the stand of the government?
Worship. Even the incident, as I've indicated at my paragraph,
But is the petitioner still working?
yes,
Still working?
yes.
Now, how many years have the petitioner rendered service?
Lordship, more than 22 years.
Yes. When, as per his statement, he joined on 2nd July 2003, Lordship.
Okay, he's still working.
Yes.
Now he wants for regularization.
Lordship.
And what is your stand?
Lordship, the thing is, even the incident is not reported in the headquarters.
Hmm?
The incident, the alleged firing incident, that the incident where he was injured, that was not even reported in the headquarters. Then there was no report, was not even submitted by the district office, nor by the petitioner himself. There was no case of
But whether he suffered a injury, bullet injury or not,
that.
and the petitioner was working as a
A voluntary home guard,
Yes,
Lordship.
he's on a daily wage. Extension is
daily wage.
yes.
So monthly pay is given
no.
by the arrangement of the state, Your Lordship, but normally they are treated as daily wage,
Yes.
daily wages, Your Lordship.
Their service is on requisition. Their service will start from 2nd July, 2nd January till 1st December. And after that, one day gap is always there.
Let's see your affidavit. What do you say out here?
Lordship, paragraph 9 of the state's affidavit, more relevant to the second part.
So you want regularization where? In the Nagaland Home Guard Service.
Yes, Your Lordship.
Now, are people regularized out there? Are they permanent appointees?
Yes, Your Lordship, the similarly situated persons were earlier regularized. I have annexed that with my petition also, Your Lordship.
The difference is, Lordship, there was no service rule.
At that point of
So
time.
there was a service rule of 1988 also, Your Lordship.
Who at the commencement of these rules are holding substantively the posts specified in Schedule A. Persons recruited to the service in accordance with the provisions of these rules, petition of science and material. Of the area of human and shall be opened by opening from among the vendor for this area, recruitment will be generation to take period of students appointment and compassion in the house, see and depending on. Now, these rules are there, but if they don't have a scheme for regularization, how do this court direct them?
Oh, my lord, yes, that I understand the difficult position of this honorable court also, Your Lordship. The only consideration that this honorable court can give is the extraordinary circumstance. In their affidavit, they have said that it was not reported, but while disposing of the representation which is cited.
No,
The-
what, no,
Yes,
what
Your
you
Lordship.
are asking at the end of the day is a regularization.
Yes,
Now, if they don't have a scheme for regularization, how do
My
this
lord,
court pass an
an
order?
extraordinary circumstance is where you cannot prepare yourself. Or the same may not be the service rule also, my lord, but given the extraordinary circumstance. And the incident took place in the office itself, Your Lordship. Medical records are there, representation was
All
submitted,
are understood,
my lord.
but you have also to understand the problem is of the court.
My lord.
How do you take care of this court's problem?
Your Lordship.
Tell me.
Ye- Yes, Your Lordship.
You have to also to think about this court. If I
Well.
pass an order to that effect, it will have a far-reaching consequences. Don't you think so?
My lord, Your Lordship.
Tell me, how do I help you? I have all sympathy for you, but how do I help you? Hmm?
My lord, an exceptional relief, an exercise of the extraordinary jurisdiction of this honorable court. I have one decision, Your Lordship, where the fault is not attributable to the candidate, exceptional relief has to be woven in favor of the candidate. Here, other states, they have a service rule where at least leaving aside regularization, Your Lordship, compensation is there. But in our service rule, our state service rule, there is no provision even to give compensation to a person who is injured on duty,
That
or
is-
even for loss of
you-
life.
You
also.
are not asking for compensation for
Yes, Your
that.
Lordship.
That is not your case.
True, Your Lordship.
Your case is different. Your case is on another aspect. Isn't it?
Yes, Your Lordship.
Then how do I take care, help you?
So, my lord, the exceptional relief
Tell me.
is that though the state
Before-
have also relied upon one apex court decision 2015 6 SCC 247.
Who
The
they
Lordship,
have relied.
state has relied on that decision saying that regularization is not permissible. But that circumstance of the case is not where a person has got shot, has received bullet wounds on duty, Your Lordship.
Hmm.
Here, it's a miracle that a person can even stand and then perform.
So you ask for
Duty, Your Lordship.
compensation, do whatever you like, but how do I pass that order?
Given
You
the
help me
extraordinary
out.
circumstance, Your Lordship,
Before the time I find out that judgment to dismiss, so find out what is there. I've almost got it. It is just coming out in the internet now. Huh?
my lord, may I understand the circumstance of a person before his own court also.
What?
Because similarly situated persons were regularized in service.
Hmm.
Now they were not in the category of the petitioner who had suffered while on duty, but still they were regularized in service.
They have regularized in service if they have a scheme.
No, not necessarily because there was a scheme. My lord, may kindly turn to page 38 of my writ petition.
Hmm.
These are the persons who were 38, my lord, page 38.
Yes. What does it say?
38. This is order dated 28 April 2010.
Eighth of April.
38, that is a type copy, Your Lordship. The original copy is it's
On recommendation
clear.
of the board,
Your
constituted
Lordship.
by the order dated to examine the proposed promotion to existing demand held on demand following home guard. So these were appointed how?
So they were recommended for regularization. They are home guards, volunteers.
This is
who
not
are
regularization,
similarly
this is a promotion. It doesn't say regularization. Does it say? Tell me.
Your Lordship, it's in the form of a fresh appointment.
Regularization, no, this is a promotion.
No, Your Lordship,
Examine the proposed promotion to the existing vacancies held on so and so.
Your Lordship, the language following home guards, volunteers.
Hmm.
So once you are a state employee, you're no more considered as a volunteer, Your Lordship.
Then what to do?
So it was considered as a promotion for accommodating the home guards volunteers into a regular post. It's not necessarily a promotion, Your Lordship.
Hmm.
So when a healthy, similarly situated persons who were not injured on duty or have suffered any circumstance or situation like the present petitioner, when they were regularized, whether this honorable court can weave exceptional relief in favor of the petitioner.
In this, so I have already got the judgment
Your Lordship.
to dismiss your case. I was just searching that. You see, that is not possible. This will be going contrary to Uma Devi. Now, although recently there are 2-3 judgments which have been passed by Justice Vikram Bhatt to the effect that Uma Devi cannot be understood in that manner. Must have gone through
Mechanical application. Lord.
mechanical application. But the fact remains, without there being a scheme of regularization by them, for this court to direct would be very difficult. The court cannot also direct them to have a scheme for regularization also. That is also barred
Yes.
the state of Jammu and Kashmir versus District Bar Association, Bandipara. So that I can't
Yes,
do.
Your Lordship.
I can't ask them to regularize, means they have to create a post. And that means I will have to ask them that forget about the rules. For Mr. Seki's client, do everything.
No, Your Lordship, I have understood what my Lord has conveyed. What I want from Your Lordship is, from this honorable court is, even if the petition is dismissed, I would not be aggrieved because given the circumstance of where the rule is not supporting, there is no scheme.
I think I will make an observation to
Yes,
that
Your
effect-
Lordship.
to that effect that if it is it's absolutely within the domain of them to frame their rules or whatever maybe, or even to absorb the petitioner if they do want to do so. And the petitioner would also be at liberty to seek the compensation, seek certain monetary compensation for the sufferer, or for the what he has suffered.
So, Your Lord, yes, Your Lordship.
That
So,
is, I think-
for a person of my client's, the petitioner's category, at least he is standing in performing duty. Some people may even lose their life also on duty, Your Lordship. Now, what is the state doing about all those things? There's nothing to give any relief. At least some observation, my Lord, as my Lord has mentioned,
Let
that
me-
extraordinary circumstance.
So let me dictate
Yes, Your Lordship.
in your presence. Wherever I go wrong, you let me know. Yes. Heard Mr. J. Saki, the learned counsel appearing on behalf of the petitioner, Mr. Kiangami. Kiangami
Lordship.
appears on behalf of the respondent numbers 1, 2, and 3. The present petition has been filed by the petitioner invoking the extraordinary jurisdiction under Article 2 to 6 of the Constitution, seeking a direction upon the state respondents to regularize the service of the petitioner to the post of bandman or quarter guardman or any other grade 4 post, as well, or to allow the petitioner to go on voluntary pension with all consequential benefits with effect from 2003, considering the extraordinary circumstances of the case of the petitioner. First, to decide the said dispute, to decide as to whether the remedy so sought for by the relief so sought for by the petitioner in the instant proceedings can at all be granted by this court, it would be relevant to take note of the facts which led to the filing of the instant writ petition. The petitioner admittedly is a casual, what is he? Casual temporary homeguard. He can be one only, homeguard, Sipo, you don't know who you are.
God's voluntary, Your Lordship.
What is he?
He's home guard
Homeguard, na?
volunteer on the daily, requisition on daily
Okay.
wages.
The petitioner admittedly is a homeguard who have voluntarily provided his service. He was appointed in the year 2003 as stated in the writ petition. First, on first of, while discharging his duties, now, first, it is the further case of the petitioner that on 1st of April, while discharging his duty, in the office of the District Commandant, Home Guards, Kohima, his superior officer, while fiddling with the 303 rifle, shot the petitioner at the Gluteal, Gluteal region of the pelvic bone. The petitioner was thereupon taken to the hospital, wherein he received treatment. First, the petitioner was discharged on 4th of April 2015 after an unsuccessful surgery. First, the petitioner thereupon continued to render his service and sought for regularization by submitting a representation on 15/5/2020 on the specific ground that he had sustained bullet injury on duty and under such exceptional circumstances, the petitioner ought to have been, ought to be regularized on head grounds so that he can avail the necessary benefits.
My lord.
The said representation having not been considered, the petitioner approached this court by filing a writ petition, which was registered and numbered as WPC number 74/2020. First, the said writ petition was disposed of by an order dated 24/7/2020, whereby the state respondents were directed to decide the said, to consider the said representation. First, it is the further case of the petitioner that the said representation was not considered in the manner in which it ought to have been done, and the representation was rejected on flimsy grounds. First, it is under such circumstances the petitioner had approached this court seeking the reliefs as above mentioned. First, it is also the case of the petitioner that the respondent authorities have adopted a pick and choose method, whereby the case of the petitioner have not been considered. On the other hand, there were 6 other persons who were voluntary home guards who were appointed to the post of,
Your Lordship, different posts.
to different posts by an order dated 28th of April 2010. First, it is seen that pursuant to filing of the instant writ petition, you have earlier filed a writ petition also, another one.
Yes, Your Lordship. This is the second writ petition.
That was also dismissed.
No, the other writ petition was before the division bench challenging the rules.
And then
The first writ petition was where this honorable court directed the state to dispose of the representation.
that is okay. That is, what is this 143?
That is,
That is also been dismissed by, I think, what is this?
No,
This
that's
is
the-
by the division bench.
yes, Your Lordship.
The-
Division bench.
You have
challenging
challenged the rules, the rules
Yes,
have
Your
been
Lordship.
negated by
But
the.
since I'm not part of the rules or locus standi, Your Lordship.
It is seen that pursuant to filing of the instant writ petition, this court had issued notice by an order dated 3/11/2020. First, the respondent number 1, 2, and 3 have filed a joint affidavit on 29/7/2021. First, in the same joint affidavit, it was mentioned that the reasons were mentioned as to why it was difficult to absorb the petitioner in regular service. First, the reasons mentioned were, number 1, the Nagaland Home Guard Act 1988, for short, the Act of 1988, do not stipulates that the service of the Home Guards stipulates that the service of the Home Guards is voluntary in nature and their service is requisitioned on daily wages basis only. Number 2, as per the service rules of the Home Guard, bracket non-gazetted 2015, and more particularly Rule 6.1, direct recruitment to the cadre of guardsmen/bandmen shall be made by open competition from amongst the candidates who possesses the qualification as prescribed for open competition. Thirdly, number 3, in view of the judgment of the Supreme Court in the case of, where's the judgment? At home. Okay.
I'm sorry.
You did not bring it. I thought, Mr. Seki, you will bring it.
I went through it, Your Lordship, but as far as the
But I have to
circumstances
put the,
concerned.
they may say many things, but I have to put the name also, na?
My lord.
The judgment should, when I'm passing an order, it should look nice. Otherwise, what will the government think? And your official, your person also is expecting a lot. He has filed so many petitions. Okay, you got it.
Yes, yes.
Then,
Forgot that I brought.
okay. Number 3. The Supreme Court, in the case of Rakshak Home Guards Welfare Association versus the state of Himachal Pradesh and others, reported in 2015 6 SSC 247, have categorically mentioned at paragraph number 22 where? Had categorically mentioned, is mentioned here. Had categorically mentioned at paragraph number 37 I have categorically mentioned at paragraph number 39 that no relief can be granted to the appellants therein, either for regularization of service or for grant of regular appointment, on the ground that the service so rendered is voluntary in nature and their requirement in service and there is no continuity of service month to month basis or year to year basis. First, this court further finds it relevant to take note of the affidavit. To take note of paragraph 9 of the said affidavit, wherein the state respondents have stated as to why the representation of the petitioner was rejected. First, as regards the appointment given to the 6 home guards volunteers to the post of bandman/quarter guardsmen, it was mentioned that these were prior to the notification of the service rules of 2015. It was also mentioned that the appointment of the 6 home guards volunteers to the post of bandman/quarter guardsmen were done as per the procedure. Detailing further in the said affidavit, it was mentioned that by an order dated 19/4/2010, a 5-member board was constituted for the purpose of appointment promotion of the Home Guard personnel. As per the minutes of the meeting of the board on 26/4/2010, the board had examined the list submitted by the respective units, which has been screened to exclude overage persons and those with doubtful particulars. Thereafter, the 6 Home Guard personnel were recommended for induction into the regular service against 6 clear vacancies. This court have in the backdrop of the plea to the affidavit in opposition, the petitioner had submitted an affidavit in reply, wherein the petitioner reiterated its stand made in the writ petition. In addition to that, it is the case of the petitioner that taking into account that it is the further case of the petitioner is that the rules of 2015 would not apply, taking into account that the said rules were notified only in July 2015, whereas the petitioner was injured in the month of April 2015.
Well,
Anything else? No more. Okay. I've heard the learned counsel appearing on behalf of the parties and have given my anxious consideration to the respective submissions. From the materials on record, from the materials on record and the submissions so made by the learned counsels appearing on behalf of the parties, it therefore transpires that what the petitioner seeks by way of the present proceedings is that a direction should be issued by this court to regularize the services of the petitioner. Direction should be issued by this court upon the respondents to regularize the services of the petitioner, taking into account the exceptional circumstances under which the petitioner, taking into account exceptional circumstances. First, this court finds it relevant to observe that regularization is not a source of recruitment, nor is it intended to confer permanency upon appointments which have been made without following the due process envisaged by Article 14 and 16 of the Constitution. Essentially, a scheme for regularization, in order to be held to be legally valid, must be one which is aimed at validating certain irregular appointments which may have come to be made in genuine and legitimate administrative exigencies. First, In the case of State of Karnataka versus Uma Devi, reported in 2006 4 SCC 1, the issue involved therein were twofold. First, it pertained to the right of the employees seeking regularization on the strength of long and continuous work. And second, the correctness of the directions issued by the courts for regularization of the employees under Article 2 to 6 of the Constitution. The Constitution bench of the Supreme Court in the case of Uma Devi Supra held that the right claimed by the temporary employees to be regularized in service on the basis of continuance, legitimate expectations, employment under the state and the directive principles cannot be sustained. In respect to the correctness of the directions issued by the courts for regularization of the employees under Article 2 to 6 of the Constitution, the Constitution bench answered the same, holding inter alia that the courts cannot direct regularization of employees under Article 2 to 6 of the Constitution. This court further finds it relevant to take note of another judgment of the Supreme Court rendered by 3 judges in the case of State of Jammu and Kashmir and others versus District Bar Association Bandipora, reported in 2017 3 SCC 410, wherein the Supreme Court observed that the judgment of the Constitution bench in the case of Uma Devi Supra was not an authority for the proposition that the executive or the legislative cannot frame a scheme for regularization. It was further observed that the state or its instrumentalities had the power for framing a scheme for regularization. That day we passed the judgment on me and Justice Manish Chaudhary was there in respect to a division bench on regularization I refer to one judgment out there of Justice M.R. Shah. Any idea? What Isha or something? This court further finds it relevant, and I'll put that citation later on. Find it relevant to take note of another judgment of the Supreme Court in the case of so-and-so versus so-and-so, where the Supreme Court had in unambiguous terms have observed that the High Court under Article 2 to 6 of the Constitution cannot further direct the state to frame a scheme for regularization. First, taking into account the above principles as have been well settled by the Supreme Court, the question therefore arises as to whether this court would be in a position to direct the state to regularize the services of the petitioner. First, the answer to the same, first, the answer to the same question would be in the negative, taking into account that any direction so passed for directing the petitioner to be regularized would go contrary to the directions of the go contrary to the directions issued by the Supreme Court, by the Constitution Bench of the Supreme Court in the case of Umar Devi Supra. First, this court also have heard Mr. K. Angami, the learned counsel appearing on behalf of the petition respondent, who submits that at present the respondent state does not have a scheme for regularization of home guards to be inducted into the services.
Home guards volunteers, Your Lordship.
Does not have a scheme for regularization. In what is that service? What service is this? It will be there in the rules, no? It will be mentioning somewhere these services, no? Services. They have, Mr. K. Angami submits that at present, the respondents do not have a scheme of regularization in the Nagaland Home Guards and Civil Defense non-gazetted service. First, taking into account that there is no scheme, in view of the judgment in the case of so-and-so, that Isha is that case, I'll give it to you. Yeah. This court also cannot direct the respondent authorities to regularize the case of the petitioner. First, under such circumstances, the reliefs which have been sought for by the petitioner in the present petition cannot be granted. First, accordingly, this court is not inclined to pass accordingly, the instant with petition stands disposed of, cannot pass any directions as has been sought for. Before parting with the records, this court, however, finds it relevant to observe that the petitioner claims that he had been affected, he had been injured while in duty, and as such, before parting with the record, this court finds it relevant to take note of a submission being made by Mr. J. Sekit, the learned counsel appearing on behalf of the petitioner, to the effect that the petitioner, having been injured on duty, the petitioner ought to be some certain exception, certain considerations are required to be given in favor of the petitioner under exceptional circumstances. First, this court have also duly given this an anxious consideration to the said respect. First, it is the opinion of this court that if the petitioner have been injured on duty, the responding authorities, being a welfare state, is required to take care of its employees who on duty have suffered. First, in that regard, the responding authorities, in that regard, first, in that regard, this court hopes and expects that the responding authorities shall take a considerate view of the matter as to how the petitioner in their view of the matter, this court hopes and expects that the respondent authorities, being a welfare state, shall take due steps for the well-being of the steps so that the petitioner's grievance of having been petitioner's grievance which still remains unaddressed can be duly redressed by the said authorities. I'll make some changes there. What can be better put? But this is
Oh, bless you, Lordship.
very difficult, but this happens. Yes, Mr. Angami, another home guard case you will require this. Take it.
For admission item number 3.
Yes, again you are there, Mr. Siki. Or this time, this way.
My Lordship, here, when the petitioner, the
But Mr.
petitioner
Longsha,
is it-
I see all the old pending cases are where you are there. Not this one. Today I was just looking into the list. All the old pending cases you are there.
Hello?
What is this?
Lord, it is to do with the last pay certificate. Now, we need an explanation on how the last pay 37,800 was worked out. That explanation has not been given, and the office of the AG, the establishment of the AG, your Lordship is fully aware that we have to strictly abide by the book.
Definitely.
So,
Now,
Your
what is the case of the petitioner? Let me have a look.
Yes, Your Lordship.
Impugn office letter dated and direct the respondents to pay the external to the petitioner as per rule with penal interest. Impugn office letter. Where is that letter? Where is the letter, Mr. Longsha? 27/7/2012. Where is it? 27. Got it. Returning of pension documents. In inviting a reference to your letter dated SAM to state that on scrutiny of the case, the following points have been observed. Was appointed as casual steno on fixed pay per month. Service was extended on year. No regularization observation order into permanence was enclosed. In this connection, he was not entitled for any nor any terminal benefit. Therefore, the office is returned. Then, Mr. Longsha, how are you going to get pension?
There is a order of this.
You have not been regularized.
Subsequently, Your Lordship.
Subsequently, the service of the petitioner, the husband has been regularized.
When?
It has been regularized with effect on.
1/4/2020, Your Lordship.
Yes.
Posthumous.
Posthumous.
1/4/2020. They were regularized.
Yeah.
Regularized with effect from?
1/4/2020.
Then he will be entitled to pension.
Lordship, yes. Now he should be entitled to pension.
Okay. Now, upon this regularization, now are you going to do the needful?
No, that is why, Your Lordship. What we want is, from that document, Your Lordship, my Lord, may kindly first come to page number 2, the last pay certificate. Pay towards the right side, Your Lordship, 37,800.
Hmm.
Now, my Lord, 40% is to be worked out from this amount.
Hmm.
And the office of the AG would like to know how this 37,800 has been worked out. Because at the time he passed away in 2008.
2008.
2008. Yes, Your Lordship.
And it has been done postponed in 2020.
Yes, Your Lordship, with effect from 1/4/2020. Now, we need to know how this 37,800 has been worked out. We need a breakup. And that is what we want from the state. The other issue is also, Your Lordship.
No,
Your Lordship.
no, this is a very important thing. The person retired on 2008,
Not retired, died.
died in 2008
Yes,
while
Your
in
Lordship.
service.
Yes.
Yes, Your Lordship.
Okay. Now you are asking LPC furnished is erroneous and actual pay as on so and so date of death may be furnished so as to work out the 40% of the basic pay for him. Who was born on so and so is no longer a minor and hence claim for extraordinary pension of his
Yes, Your
late
Lord.
father may be proposed in his favor. May not, Mr. Seki, kindly come to serial number 2 of page
Yes, Your
1.
Lordship.
So and so, eldest son of so and so who was born on so and so is no longer a minor
Yes, Your Lordship.
and hence claim for extraordinary pension of his late father may be proposed in favor of him.
Yes, Your Lordship, because the present petition is in the form of a guardianship, Your Lordship. And now the actual son is already a major.
But how will he get pension then?
His father's pension till the age
How?
of 25, Your Lordship.
You give it till 25.
Yes, till he reaches 25 years.
Okay. The original service book in so and so was taken from the year on 2000 until date. It has not been returned to this office. Okay. So in view of this, the state is required to do the
Yes, Your Lordship. Once they do that, there is no more issue, Your Lordship.
Oh, I passed some order earlier. Oh. Mr. J. Saki, the learned counsel appearing on behalf of the Accountant General, Office of the Accountant General, Nagaland, submits that a communication have been issued on 2/4/2025 to the Secretary Home seeking various clarifications. The communication is being placed before this court, which is kept on record and marked with the letter Y. Full. Mr. So-and-so, the learned counsel appearing on behalf of the respondent state submits that as the communication have been issued only on 2/4/2025, and a copy have also been provided to him by Mr. J. Saki, appropriate action would be taken by the state respondents at the earliest. Full stop. List this matter again on 6th of May
Madam,
2025 for an update as to whether there has been due compliance, as to whether the respondent state have taken appropriate steps in pursuance to the communication dated 2/4/2025.
Respondent number 3. Particular, that is all.
Respond number 3.
Yes, you must.
Your respond number 3.
Address to respondent number 3.
Okay, respond number
Madam.
3. Full stop. Mr. J. Saki, appearing on behalf of the Accountant General, shall also apprise this court as to whether the respond number 3 have duly taken steps.
Madam.
Madam.
And if so, what's the status before the Office of the Accountant General?
Madam.
Madam.
Please take on.
For admission, item number 4.
Please, Your Lordship, I'm appearing on behalf of my senior Alan Kumar. Regarding the contract defeat filed by the respondents, we will be filing a reply. So kindly allow us to reply.
Last chance.
Yes, Your Lordship.
is seen from the records that on 1/3/2025, the affidavit in opposition has been filed by the respondent, by the official respondents. And the petitioner thereupon have sought for time for filing the reply on 17/3/2025. The counsel appearing on behalf of the petitioner seeks a further accommodation, taking into account the matter pertains to the year 2022. A final opportunity is being granted to file the affidavit in reply. List the matter again on or before the next date. List the matter again on 16th of May 2025. It is observed that if no affidavit in reply is filed on or before the next date, the court shall proceed on the basis of the materials already available on record.
Item number 5.
Lordship state has filed additional affidavit, for which we have sought time notification. We have filed state additional.
You have filed the additional affidavit?
Lordship.
Yes, madam. What do you have to say? What do you want here? Impugn appeal written by the so-and-so to demand giving approval to the appointment of heir to the post of carpenter against the vacancy caused by so-and-so. What is this matter, Mr. Angami?
Lordship, is on landowner basis. The petitioner is challenging the appointment of the private respondent who is appointed on compassionate basis. Right? Claiming that
Respondent was appointed on compassionate basis
yes.
in the year 2022. So what is your stand now?
Lordship, now the latest additional affidavit which we brought in says that appointment has already been given. On landowner basis to the uncle of the petitioners, so he no longer has locus right to challenge.
Your Lordship, the leading counsel for the petitioner is on leave.
No, I'm asking you, what do you have to say? How many years of practice?
Last year. Last year.
Huh?
I've joined only last year.
So what is your submission should be? Have you heard, madam, have you heard what Mr. Angami has said?
Yes, Lordship.
That your claim out here is that you should be given appointment on landowner basis.
Yes, Lordship.
The case made out by the state is your uncle have already got the benefit. So the question of you getting benefit does not arise. And it is on the basis of an additional affidavit which has been filed by the state. So what should be your submission now? Tell me.
Your Lordship, since my senior is on leave,
I'm asking you, what should be your submission? Ms. So-and-so, the learned counsel appearing on behalf of the petitioner submits that taking into account that a new stand has been taken by the respondents by bringing on accord the additional affidavit, she would like to obtain necessary instructions and if necessary, file an affidavit in reply. Taking into account the above, lists the matter on 8th of May 2025. The affidavit in reply, the petitioner, if so advised, would be at liberty to file the affidavit on reply on or before 6th of May 2025.
Mashallah, Lordship.
Item number 6.
Please, Your Lordship.
What is this?
Lordship.
Regularization.
Lordship,
Under what provision?
Lordship. Under Office Memorandum dated 17/0/03/2015, Lordship.
You have completed 30 years.
Lordship, in the year 2022, Lordship.
On scale of pay,
Lordship.
Yes, Your Lordship, that is the problem we are facing, Your Lordship. The reason why I could not able to file an affidavit, Your Lordship, is because I received the petitioner's prayer is to be covered by that ON, 30 years, so as per the ON, he should be entitled. Now, I received an instruction from respondent number 2, that is PNAR. And Your Lordship, from the instruction I received, the finance already rejected the case of the petitioner, stating that scale be granted to the petitioners is not as per the extant rule. And therefore, the department, if the department has given any scale pay to the petitioner, for that matter, there are also another 52 persons along with the petitioners. So the department should take step to reject their scale of pay, to withdraw the scale of pay. Now, after receiving that one, Your Lordship, I inquire from the nodal department, from the department, Your Lordship, as to what steps the department has taken. The department, again, Your Lordship, after the rejection, they actually wrote again to the finance again for reconcurrence, Your Lordship. The last being,
Madam, that's 17/3/2015
Yes.
notifications say
yes, Your Lordship.
that the scale of pay granted properly
Yes, Your Lordship.
only would be considered, or it says
You'll-
that if a person who has served for 30 years
30 years, that,
and on a scale of pay
yes, Your Lordship,
would
that's,
be entitled to be considered for the purpose of regulation.
that's right,
automatically.
that's right.
That was also the submission of the AG when I took up one matter where I passed. I think you were there in that matter. I delivered a judgment in respect to that where I heard the AG also in that regard. So he differentiated the 2004 and the 2015.
Yes.
2004 is a person would, irrespective of anything,
Yes, Your Lordship.
will be a work charge employee would be entitled for regularization provided there is a vacancy. Whereas in the case of 2015, a person who has been given a scale of pay and have got 30 years, he automatically gets it.
Yes, Your Lordship.
Now, why are you raising this issue of scale of pay, no scale of pay, rightly or wrongly granted? How are you going to now recover it from him?
No, Your Lordship, that actually, it seems that like the scale of pay, when it was routed, like, it was not taken the concurrence of the finance, Your Lordship. It was not routed through that, right? It was done like that, Your Lordship. So the finance, finally, Your Lordship, for
in fact-
regularization,
in fact-
when the matter was put up.
Madam, the problem is I see out here
Yes, Your
that you don't have also a proper circular
Yes, Your
as to on what basis you are going to give a scale of pay also. Nothing is there. Somebody wants him to be given a scale of pay, he's being given a scale of pay. Somebody is not given a scale of pay, he's languishing out there on a fixed pay. This is what is happening. Isn't it?
No, please, Lordship. Lordship, this is the second round of litigation. The petitioner have already filed a with petition WPC 159 of 2022. And this court has directed the state respondent to consider the representation of the petitioner. And while the petitioner was awaiting for his regularization, he retired in the year 2022, Lordship.
You do one thing, you bring on record your stand.
That's why, Your Lordship,
You bring
just
on record your
sometimes.
stand, but the fact is, it goes against what you are professing.
Yes. Now, Your Lordship, to determine
The
the case.
petitioner
sometimes-
herein, because you completed 30 years when?
2022, Lordship.
22.
31/07/2022.
So you have another 22 means by 2037, 22.
2022, Lordship. I
Okay, by
completed.
2022, you have 30 years, another 5 years.
No, Lordship,
Will be
the
20.
petitioner is already retired through supernation, Lordship,
Oh,
in the year 2022.
retired.
Already retired, Lordship.
And how many years you had then?
Lordship,
How many years did you have then? When did you complete 30 years?
31/07/2022, Lordship. 30 years. And
And on that day you retired.
by order, release order dated 09/11/2002, I was released from the service, Lordship.
22.
Lordship,
Why? After you reach
Superannuation,
58,
Lordship, yes.
58.
Yes. 60 loss.
Okay. Ms. So the learned counsel appearing on behalf of the state respondent submits that that upon seeking instructions, it appears that the finance department have rejected the claim, have informed the parent department wherein the petitioner was working that the scale of granting of the scale of pay to the petitioner was not by taking the concurrence of the finance department. And as such, the question of regularizing the services of the petitioner in terms with the OM dated 17/3/2015 did not arise. First of all, she further submitted that the parent department where the petitioner was working, however, has again written back to the finance department seeking the concurrence. Full stop. She therefore submits that some further instructions is required to bring on record the affidavit in opposition. Full stop. Taking into account that the petitioner have already retired in the year 2022, which is almost 22, this court fixes this matter on 22nd of May 2025. The respondents are directed to solve the issue pertaining to the case of the petitioner and file their affidavit. The respondents amongst themselves are directed to solve the issue, their respective issues, and file their affidavit on or before the next date.
Well, Lordship.
I
Much
think
obliged.
with this, you can get the handle.
Yes, Your Lordship.
Obliged, Lordship.
Item number 7.
Please, Your Lordship.
Hmm.
Lordship, I beg to mention on behalf of my.
Don't mention, don't mention. Mentioning is not there. Mentioning is at 10:30. Now we are coming here. What is there? Yes, madam. What is it?
Yes, Your Lordship, in the previous day, this honorable court have instructed.
What are you asking here?
Of, for vacancy.
Hearing the Your Lordship direct the responsibility of dispose of the representation by speaking order. You are asking a speaking order. That's all. What is this speaking order you are asking? Annexure E. Let us see if I can give you a speaking order. With due deference and reference to the context above, I understand that with the successful completion. But till date, we have not been assigned with the post to anyone within the state of India. 4 months after the completion. Home Guard,
Yes, yes.
where is Mr. Angami? Your senior is who?
Moin, Your Lordship.
Where is he? Not
It's
there.
not-
So
not
what is
there.
your submission now? Tell me.
Lordship, I have instructions that he has obtained for further instructions, Lordship, as per the order dated 18/2/2025, Lordship, which he is yet to receive, Lordship. So if further 3 weeks time may be granted, Lordship,
For what?
to obtain instructions, Lordship.
No, he's asking for a simple prayer. He's not asking for anything else. What is the prayer asked for? Look at this. They appoint the AI as home guards, volunteers. They want to be volunteers. What is there? Please help us. These are such petty matters pending. We need to finish it off. What is her prayer in the case? That these people were appointed in the year 2000. They have completed a successful training in the year 2018. Okay. As for the purpose of home guard. Thereupon, they are seeking that they should be assigned some job or whatever may be on daily basis. So this is the representation which has been submitted. So they want an order passed by this court that their representation be considered. What is this matter to be pending from 2023? Where is Mr. Angami, K. Angami? He's a home guard expert. Where is he?
My lord, as a last chance, we may be granted 3 weeks' time.
No. This type of matters cannot happen like this. You see, she's only asking for a purpose that give me my representation
My lord,
be disposed.
Normally, those volunteers are appointed on exigencies of service.
So
If the
therefore,
exigencies of service is
so
not.
therefore the submission
Yes,
should
ma'am.
be that as per the rules, it
Yes.
is on the exigency of service they
Yes,
will
ma'am.
be called for.
Yes, ma'am.
So that will be considered
Yes,
by
ma'am.
them,
Yes.
they will be considered.
May I pray that 3 weeks' time?
But you can't allow them to wait for another 7 years. This is 7 years after the training. They completed the training in 2018, isn't it, madam?
It's
So they want something, a final solution. You know, you say that we will call them if necessary. That's all. That is the only thing they are asking for.
Normally, those volunteers, they were selected to undergo training for basic training course. After completing the basic training courses, they are not entitled for immediate appointment.
No, it's okay, but this is not immediate after 7 years.
Yes, ma'am.
Yes, Mr. Angami. You see, here the case is very simple. These people have completed their basic training on Home Guard on 8/3/2018. Their only grievance is that till 2023, you have not even asked them to come once. And for that, they have submitted the representation. Why you are not considering matter over?
The representation, Lordship.
Yes, you need to only consider any, you feel so, because this is voluntary service.
Yes, sir.
Your thing is you will have to take him on the basis of exigency or no exigency.
Lordship.
If you have exigency, okay, you want them because this is a voluntary service.
Lordship.
So you may not require them.
Lordship.
You have to give a reason. You have trained them very well. Give a reason why you don't want them.
Lordship. Lordship. Lordship.
Why should this court judge whether you should want or not? You take a decision.
Lordship.
If your decision is wrong or right, madam will again come. Isn't it, madam?
Yes, Your Lordship.
Yes.
Yes, yes, Lordship.
Do that.
Yes, sir.
This matter cannot be kept pending for like this. Level. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. K. Angami, the learned counsel appearing on behalf of the respondent. The petitioners herein the case of the petitioners herein is that pursuant to an advertisement dated August, advertisement issued in the month of August 2017 by the Office of the Director General, Home Guards and Civil Defense. The petitioners have participated in the interview which was conducted on 19th to 20 September 2017 for female candidates and from 21st to 22nd September 2017 for male candidates. Fuster. After undergoing the said, thereupon, the petitioners have undergone 3 months Home Guard volunteers basic training at Central Training Institute Home Guards and Civil Defense Dimapur with effect from 8/1/2018 to 8/3/2018. After completion of their training by release order dated 7th of March 2018, the petitioners along with others were released from the training institute. The grievance of the petitioner is that even after completion of their training, the petitioners have not been assigned any duties And as such, the petitioners have submitted a representation on, what is the date, madam? No date.
On 7/3/2018.
Huh? Had submitted a representation, which is Annexure E to the petition, requesting for immediate posting of the petitioners. Full stop. The said representation was forwarded by the Deputy Commissioner Longling, Nagaland, to the Director General Home Guards and Civil Defense. Full stop. However, as no steps were taken in respect to the said representation, the petitioner, being aggrieved, has approached this court. Full stop. This court duly takes note of. This court duly takes note of that by an order dated 21/8/2023, notice was issued, comma. There has been no affidavit filed on behalf of the respondents in spite of a passage of more than 1.5 years. So today also, time have been sought for on behalf of the respondents seeking for filing the affidavit. Full stop. Full stop. This court further takes note of a communication being produced by the learned counsel appearing on behalf of the petitioner, a respondent, to the effect that on 15th of November, the Director General, Home Guards and Civil Defense have informed the council that the department is under active consideration to offer the appointment orders to the petitioner number 2, 3, and 4 in the present petition. It was also mentioned that the appointment letter is issued to the candidate as per availability of the vacancy in the district. As such, it is because of non-availability of the post, the offering letter could not be issued to the aforesaid 3 petitioners. Hence, more time was required. Full stop. The said document, which have been placed before this court, dated 15th of November, is kept on record and marked with the letter X. Full stop. This court, taking into account the above, directs the respondent authorities to consider the case of the petitioners for offering appointment letter subject to availability of vacancy in the district and also subject to the exigency of the department. First, with the above, the instant writ petition stands disposed because it is your stand you are offering. What is there?
Item number 8.
Yes, what is this?
Please, my lordship, this is termination of the petitioner. My lord will kindly come to, the petitioner was appointed as constable in the police department. My lord will kindly come to page 18. That is the first termination order. Lord, she will kindly appreciate that I have
Yes, what is your ground?
my ground is that I have been terminated from service. 18C is the first 18, page 18, lordship.
without any notice.
But that has been already set aside.
Yes, yes, Lordship.
Let us know.
Now the order is page 19D.
Page
19D.
19D,
D, Lordship. Annexure D.
Annexure D.
Yes.
Where is D? Yes.
6.
Page
Page 20.
20. Page 20. Oh, wait.
Page 20, paragraph 6. In the first repetition, the direction.
I have only one petition with me. Page 20 is the disorder of Justice Michael.
Yes, yes. Lordship.
Then what happened?
Paragraph 6.
Then no notice. Okay, now come to the point. What is there next?
So, as per the direction of this honorable court, I submitted my prayer for reinstatement as directed by the
So
honorable court.
thereupon the inquiry was initiated under 9(2).
Yes, Lordship.
After that, what happened? They have given you a charge, articles of charge.
Yes, Lordship, in the first place, my lord will kindly.
Discipline
First-
proceedings against so-and-so daily order sheet. To which he replied that he admits and pleads guilty to both the charges, articles, and framed against him. Now, therefore, based on the aforesaid proceeding, the report of guilty is contemplated. Then, show cause is been given the second show cause notice. Will show cause as to why he should not be terminated. Now, the order is being given that he has been terminated. Now, what happens? What remains?
Lordship, here what I want to pray before this honorable court is that the show cause notice was issued on.
Madam, did you admit guilty?
I say that I slapped the cook, that we stay together, I slapped the cook twice. So here comes the quantum of punishment, Lordship.
So you are on the question of quantum.
Yes, Lordship.
And if you slapped the cook, let us see the show cause. What is the
Show cause
allegation?
notice,
Where is the allegation?
page 34G, annexure G, Lordship.
34.
Yes, this was issued on 5th.
Orderly room was conducted by so-and-so, commander name, and the officer submitted the orderly room report and stated that Lincoln admitted his guy. Now, whereas so-and-so was appointed as a constable in manner of completion of training him was attached with so-and-so. Under the influence of any man handled so-and-so who was attached with so-and-so. Shortly after the delinquent so-and-so submitted in his statement that he would accept whatever punishment in case terminated. So-and-so is of the found the last damage that during the post inquiries. Said in man under the influence of inquiry. Yes. What is wrong? Why did you
Lordship,
slap
in the first disciplinary proceeding, that is at page 33, I have already admitted to the disciplinary proceeding that, yes, I slapped the cook twice on the face. And Lordship, here, I have already admitted here, my lord will kindly come to page 33.
Madam, I have seen it. Now the question
Lordship,
is, how can this court override the quantum in respect to a discipline force?
Lordship, here one aspect is that this show cause notice was issued on 15th. 5th of my lord will kindly come to. Oh my God. Lordship, I was attending a funeral and I was a little bit unprepared. That's why I beg your pardon.
So you want time?
F2, Lordship.
Not to. Do I have some other matter? Lots and lots of matters. The fixed matters. But your
Otherwise, I will just,
I've got your point. Your case, let me say, your case is first, you were terminated without notice, so you challenged it before this court. Once you challenged it, this court said that without a notice, you could not have terminated him. And as such, set aside the termination order, and thereupon you filed 2 representations for reinstatement. After reinstatement, they have issued a memorandum of charge to you along with articles of charges wherein it has been mentioned 2 charges. First, you have person who you have you have manhandled a particular person, and which is in violation to Rule 4 of the Nagaland Government Service Conduct Rules 1968. And secondly, you are being a member of the disciplined forces. You could not have done all these things. The matter goes there, you submit that you are guilty. Yes, I have done all these things. Thereupon, an inquiry report is being submitted. After that, you have been given the second so-called notice. You again say that, okay, I'm guilty. I'm willing to take up all whatever punishment it is. You say that as you have admitted yourself, they should have been more lenient instead of terminating. Isn't that your case?
that is my case here. Only one aspect, Lordship. The order at page 28, 5th April 2021, setting up inquiry as well as page 29, memorandum. These were issued to me. It was issued on 5th April 2029, but I received all this show cause notice after 48 days, expiry of 48 days. That is my humble submission before the
Did
Honorable
you
Court.
take that ground in your written statement of defense?
Yes, Lordship.
Show us. Where's your written statement of defense? You have not enclosed your statement of defense even.
Submission of written statement is at page 39.
Page?
Page 39. The government's acknowledgement receipt as well as my acknowledgement receipt will show, Lordship. They served me after expiry of the 48 days.
So how does it matter?
That means I was terminated before I could submit my written statement after they provided me the show cause notice.
Huh?
Yes, that is my case, Lordship.
You got this when? On?
Lordship will kindly come to page 38.
Okay. You submitted on 24/6/2019.
Yes, I received the show cause notice on 4/6/2019. They issued on 15/4/2019. Page 38 will see receipt. The government receipt is at its same, Lordship. They received my receipt that I have annexed, and these are the receipt that they furnished me. They did again reinstatement. They did not furnish me. That's why in my read.
Okay.
No, please, Your Lordship. Your Lordship, yes, if you can kindly come to,
When did you serve the show cause notice?
the show cause notice was served on the,
4/6.
yes, it was served on 15/4/2019. Your Lordship.
No, not this show cause notice. Memorandum of charge. When did you serve?
Remember, Your Lordship, memorandum of charges, everything was, Your Lordship, issued on 5/4/2019. Your Lordship, the petition was asked to come for preliminary inquiry on, Your Lordship.
Their acknowledgement receipt is at page 20, lecture 9 of their affidavit in opposition.
12/4/2019.
Huh?
Your Lordship, if you can kindly come.
When did you receive so you have the records with you?
Yes, I have the
Now
report.
give it to me.
My affidavit, Your Lordship, if you kindly come to my.
Statement of the.
Page 20, Your Lordship.
Your affidavit.
Page 20 is the acknowledgement receipt, Your Lordship. The
No,
show-
first you terminate on 5/4/2019,
Yes, Your Lordship.
isn't it?
Yes, Your Lordship. After that, Your Lordship, they came before the,
Partial data money in order to arrive and give a survey of the results, he's felt necessary to consider the departmental inquiry. So for 5/4/2019, you institute a departmental proceedings.
yes, Your Lordship.
Dated 5/4/2019,
Yes.
and the memorandum of charge is given on 5/4/2019.
They only, yes, Your Lordship.
Now, when did you receive this?
That receipt, Your Lordship,
My-
I don't have the copy of that receipt. However, he appeared for the preliminary inquiry, Your Lordship.
Okay, then today, a date, a copy of the order dated so and so has been received appointing me as the appointing officer. Okay, then submission of departmental inquiry officer on 12th of April. 12th of April. Okay, disciplinary proceedings against the Hosea. Now you have asked him to
After,
submit his reply when
Your Lordship,
he's directed to submit his reply within
That
10
also
days.
54.
yeah,
10 days of the receipt of the memorandum. Okay, and now, oh, here. What have you done? You give a memorandum on 5/4/2019.
yes, Your Lordship.
And kindly come to page 9 of your affidavit.
Yes, Your Lordship.
So and so is directed to submit within 10 days of the receipt of this memorandum a written statement of his defense, and also to state whether he desired to be heard in person.
Yes, Your Lordship.
Okay.
Yes, Your Lordship.
You did not inform him to come for anything because without, as per the, you go by as per the Nagaland's rules of 1965, isn't it your case? So if that is done under the 65 rules, 64 or 65 rules, then in that case, he has to answer to the written memorandum of charge.
Yes, Your Lordship.
After the memorandum of charge, I think you go by rule 9. You have the rules?
That,
Madam, you have the rules?
Yes, Lord.
Give it to her.
Disciplinary. One is this.
Yes. Rules? Is this the rules?
No, discipline appeal receipts.
Okay. Kindly come to rule 9.
Can my lordship?
Yes.
Yes,
Tell
Your
me,
Lordship.
how is it, how an inquiry is done?
The Lordship, this is rule 9, it's procedure for imposing penalties
Read it. Show it to me.
with prejudice to the provision of public servant 1850, no order imposing on a government servant any of the penalties specified in rule 7 shall be passed except after an inquiry. After an inquiry held as far as may be in the matter hereinafter provided. The disciplinary authority shall frame definite charges on the basis of the allegation on which the inquiry is proposed to be held. Such charges, together with a statement of the allegation on which they are based, shall be communicated in writing to the government servant, and he shall require to submit within such time as may be specified by the disciplinary authority a written statement of his defiance, and also to state whether he desires to be heard in person. Standard form of memorandum of charges, charge sheet and memorandum are specified in schedule 4 and 5.
Now, where is the remaining part of rule 9? There's further there. Give it to me, that book. Now see. Now she has not given you the read. You see, kindly see this. She has not given you the right portion. 9.3. Because this is same like the 64 rules of Assam, so I remember it. Kindly come to rule 3, 9.3.
Yes, Your Lordship.
Yes.
The government servant shall, for the purpose of preparing his defense, be permitted to inspect and take extract from such official records as he may specify, provided that such permission may be refused. if for reasons to be recorded in writing in the opinion of the disciplinary authority, such records are not relevant for the purpose or it is against the public interest to allow him access thereto.
Then
Provided
9.4,
on receipt of the written statement of defiance, or if no such statement is received within the time specified, the disciplinary authority may itself inquire into such of the charges as are not admitted, or if it considered it necessary so to do, appoint for the purpose of board of inquiry or an inquiring officer.
okay.
Yes.
Now tell me, how did you appoint? You issued this notice on 5/4/2019.
Yes, Your Lordship.
Okay, this is as per 9.2. Okay,
This is issued.
this is as per 9.2.
Yes, Your Lordship.
Okay. Yes, madam, kindly don't take that book from her. Where have you taken that? Yes. This is done as per 9.2.
9.2, Your Lordship.
Then 9.3,
Yes,
that delinquent has a right of seeking inspection.
Yes, Your Lordship.
You may give inspection, may not give inspection. 9.4, the delinquent may file a written statement or no written statement. If there is no written statement, the board may, the disciplinary authority may appoint an inquiry officer, or the disciplinary authority can do it by itself. Okay. Now you have an inquiry officer. See the facts out here. You have an inquiry officer appointed on the date on which you have appointed the memorandum charge. 1. He had time to file the written statement by 15th of April 2019. Isn't it? 15th of April 2019, because it was issued on 5th. At least, if you have served that document on 5th,
Yes, Your Lordship.
he had the right to do it by 15th because you have given him 10 days.
Yes, Your Lordship.
Then how can there be an inquiry officer
Exactly.
decide and pass an inquiry report on 12/4/2019? That is the case.
Your Lordship,
And
yes,
you have done.
that actually has not been projected. That is not the case.
That is not
The case is
required.
that, I mean,
She
the show
is-
cause notice, she has received the show cause notice.
Madam is too busy for other matters. There are a lot of matters, so it's not. That is why I'm helping
Yes,
you.
yes, Your Lordship, it's our duty to assist you.
That is the issue.
Yes, Your
How is it possible?
Yeah, that part, Your Lordship.
It cannot be. You cannot have it, whatever may be, guilty or not guilty, whatever he may say. But as on 12/4/2019, there could not have been even an appointment of an inquiry officer.
Yes, Your Lordship. Yeah,
Because he had the right to file his written statement on or within these 10
within
days.
the period,
10 days.
30, within that period. Your
So
Lordship.
on that basis itself, the inquiry officer goes, this inquiry report goes. And without an inquiry report in view of 9.1, there cannot be the penalty be imposed.
As far as the rule is concerned, yes, that, Your Lordship, I cannot go beyond that, Your Lordship, because apparent from the record, Your Lordship. However, the petitioner, I mean, the delinquent appeared.
No,
On
so
the
what
preliminary
is
inquiry.
required to be done is,
Yes,
now the problem arises here, as of now, the petitioner, this inquiry report has to be set aside, this termination has to be set aside. Now, the question is, if I have to set aside, what is the consequences now? The consequences is he gets his back pay. On the ground of no pay, no work, you can very well take another aspect of the matter. Or we can very well say that let it be decided out there, fresh air. And depending upon that, depending on such decision, the petitioner's entitlement will be done. But otherwise, he's entitled to the back pay. This termination is illegal.
Exactly.
What do you say?
Lordship, yes, as far as the.
Think it over.
Yes,
I'll take it up on Monday.
maybe,
Monday.
okay. Your
It's a
Lordship.
simple
No,
question.
no problem. no
Just
problem.
think it over.
Okay, Your Lordship.
Because only otherwise the remaining problem is not there. But the problem is it will be from 19 till 2025. It's a huge period, 6 years. Now there will be backwages question.
Now, my question is also, that is not being projected by the petitioner, Your Lordship. In the petition, the only thing is that she has received a show cause notice after the, after the expiry of the period. That is the case.
That is also-
This is not the case, your lordship has brought up. But anyway, your lordship, since it has come up, your lordship, we will.
Lordship,
Look
in
into it.
fact, I received only on 4/6. 4/6, not 4/15/5.
That is
No,
it.
no, no, no. You receive 4/6, the second
Yes,
show
sure,
cause.
Cosmo.
Sure, second show cause
We are not
notice.
concerned with second show cause. Because second show cause order has been passed on 14/6.
Lordship.
The termination order is on 14/6. So
There's
you're not
nothing
on that.
wrong.
Your basic, that case, if you are projecting, your case is gone.
It's only that part, your lordship. That's why I have also answered on that.
What
your
to do?
lordship, Everything.
Tomorrow they may file an appeal on that ground itself. That there is no pleadings.
Lordship will kindly, if it comes up on Monday, I can just file an
Monday or Wednesday, Tuesday,
Tuesday, Lordship.
you can file an additional affidavit.
Lordship, I shall do
Just
that, I shall do that.
Only thing is bring it on record that thing you want.
Lordship, Lordship.
Lordship.
You in the meantime think over
Yeah, oh, yeah.
and file it by Monday because then
I
madam
will.
will say out here the look.
Lordship,
here,
Lordship.
I have just looked it now. How will I know?
Lordship, I will contemplate on that. Your lordship.
Because this is a very
Your
important thing.
lordship.
How is it done?
Yes,
And
your
this is the mostly the mistake. Otherwise, too, this is not a case of interference at all.
excellent. Correctly pointed out, your lordship.
And procedure is wrong.
Very much, Lordship.
But that is not the case. That is my point, your lordship. There is nothing.
No, I have already projected, Lordship. Lordship, you kindly see my.
No, madam, kindly don't say, Madam Jimumi, kindly don't say, because from your own conduct, it shows that you never took, because this document which you are placing before her and me does not contain 9.3 and 9.4, which is the case of the, I have made out.
Lordship,
Okay.
if my last representation to the Director of General Police, I have set out everything. My last representation.
Understood. Do you want to file an additional affidavit?
Yes,
You
Lordship.
file it in the.
I shall do that, I
Just
shall
bring it on record on Monday, a
Lordship.
short affidavit.
By Monday.
On Tuesday, let me take it up. So matter being heard at the length, this court would further hear this, the councils on the next Tuesday to go to Tuesday on 8th of April 2025,
Lordship.
showing it to be parted. Ms. So-and-so appearing on behalf of the respondent shall produce the records on that. One matter. Everybody is with.
Item numbers 9 and 10.
You have filed affidavit,
Your lordship,
state,
yes, I have signed for responding 1, 2, 4, and 5.
state has filed
Yes,
affidavit.
but I will pray for few days to file my affidavit for responding 3, your lordship. I send it for writing everything.
Okay, the council appearing on behalf of
The
the.
last petitioner have raised the issue on the benefit of rejection. Because the issue raised by petitioner are all Muslim facts. This honorable court has directed the deputy commissioner to do a survey of the land where the petitioner is claiming that these are legal. It has been verified.
Mr. Mojo, kindly appreciate. The moment I ask her, she will say that her senior is not present. Say that. So, and she has only 1 year of practice. So better off grant her human adjournment, isn't it, madam? So Mr. So-and-so appearing on behalf of the respondent number 3
Respondents.
submits that she would request some more time for filing the affidavit. So he further submits that the said affidavit has already been sent for vetting and would be filed in a quick span of time. So list this matter again on 24th of April 2025. The affidavit of the respondent number 3 be filed on or before the next date. Mr. Mujo, as the learned counsel appearing on behalf of the private respondents, have assailed have challenged the maintainability of the writ petition. Full stop. The said aspect, the maintainability of the writ petition shall be adjudicated on the next stage.
Buruk na nga. For judgment, item numbers 1 and 2.
Ms. Livika, kindly take the records, huh? The records are there. The blue record, no, the blue records. You got it? Okay. Set aside the detention order, the confirmation order, as well as the extension orders. The detainee so-and-so be released if not required for detention in any other cases. I've also marked a copy of this to the advisory board, taking into account that the advisory board is still hanging into an order judgment of 1975. 1975 judgment says that a person who is in judicial custody can be still put into a preventive detention. But the law has then changed a lot. But it seems the advisory board, where is the one of the persons of the advisory board? Where is Mr. Sentianger? He is a member. They seem to be forgetting to take note of the law. It's very sad. But there cannot be a same type of case every time. Every time. Today, he is going to mention one more matter. Same thing. Isn't it? You are appearing for which one? Who is appearing for Jekis? Who is appearing for the detainee Jekis? Okay, so you are caught because of him. A person has been put into preventive detention, but interestingly, you have not been able to get the FSL report as to whether the goods is heroin or not till now. Can it happen? Huh? The saddest thing which has happened. We have observed one paragraph. I think it's high time to read it. Yes. All these aspects were not at all considered by the detaining authority, the confirming authority, the central government, as well as the advisory board. It appears to us that it has escaped the attention of the said authorities that preventive detention laws have the effect of taking away the liberty of a person without any trial, and therefore the authorities have to be very careful in exercising such powers. We find it very pertinent herein to observe that in spite of various judgments pronounced by us as well as by the Supreme Court as to what parameters are required to be followed to invoke the powers of preventive detention, when a person is in judicial custody, the authorities of the state of Nagaland seems to have ignored it. Even the advisory board constituted seems to have overlooked these vital aspects. We find it relevant to observe that the advisory board is bound to follow the law laid down by us as well as the Supreme Court. We, upon perusal of the reports of the advisory board, express our concern the manner in which the advisory board have dealt with the matter and submitted its reports in both the cases. Yes, yes.
On 2 April,
Hmm.
Dismissal court has.
Oh, there was a mistake committed by us and fixed it on 11. When is your period ending?
May.
May. In the month of May. Okay, let us take it up on Wednesday then. Huh? Yeah, we'll pass an order there, no? And put it out there. The counsel appearing on behalf of the petitioner expresses great urgency in the matter. He further submitted that the matter was actually fixed up today, but however, inadvertently, the order has been passed that the next date to be fixed on 11/4/2025. Taking into account that this is a preventive detention matter, we direct the registry to list this matter on the next, on Wednesday. Okay.
Sure.
Yes.
Matter pertaining to Itanagar bench to be taken up via VC. Item number 1, WPC 82 of 2025.
Can you make it bigger?
Yes.
Yes, Mr. Das, what do you have to say?
So, an affidavit has been filed by the, as directed by the court. An affidavit has filed by the.
You filed an affidavit?
They filed, because you are also there on the last occasion. That your lordship has elected an affidavit has to be filed. Accordingly, they have filed an affidavit. Just now, we received by WhatsApp. Yeah. I have no lordship, but it.
Yes.
Send the copy. Lordship has seen that affidavit filed. But one of the main arguments before your lordship will be, there are two propositions which I have developed. One is that keeping 235, because there are two judgments of the Honorable Supreme Court. One is 1992, which is followed earlier judgment. 1966 judgment. Then, if your lordship, because we are in 235. Yes. 1965, my lord. That is state of West Bengal dependent on Bakshi, my lord. Their judgment. Now, in their judgment, now the issue whether the state government can invoke the CCS rule in case of judicial officer. That was the issue before the Honorable Apex Court. Now that was a constitution bench. Now the constitution said that no, where is the question of CCL rule to be applicable? And the rule to be applicable in respect of the district judicial officer in respect of the CCS rule will not be applicable. So this was the issue before the constitutional bench. And this at 235 has to be followed. So forget about the CCS rule. Now, another 1992, another issue has cropped up, which your lordship has looked into it. And what was that issue? The current Gujarat case, yes. RN Gujarat case.
Can you give me the 66 judgment,
66.
the West Bengal judgment?
I'll just give a copy, it's important. First, your lordship will look into that 19, because they referred. I got a copy. Because that judgment was referred. 1965 judgment was referred. Just may I read that, madam?
Which one?
That copy. It's 1965. You also.
You have a copy?
I have got. I just. It was.
Okay,
there.
no, just
I
read-
got it.
no,
I
I'll
got
get-
Kindly see 1965.
Yeah,
Year 1965. 65. SCC online SC 22.
no, what is the AIR citation?
1966 Supreme Court 447.
447.
1960,
66.
SC 447. 447.
ৱাইফাইটো লাগিব হ'ল মইতো ভইচটো পোৱা নাই
Yes, Mr. Chaudhary, for whom are you appearing?
Oh, yes, muted. What is
66.
See, kindly see para 4. Para 14, sorry, para 14. My lord, Miss Lordship, what is
Yes.
para 14?
Yes.
Mr. B said appearing for West Bengal government contains word control must be given a restricted meaning. He deduces this A on a suggested reading of Article 235 itself and B on a comparison of the provision of Chapter 6 with those of Part so and so of the Constitution. We shall examine these two arguments separately as they admit of separate treatment. The first contention is that control means only control of day-to-day working of the courts, and emphasis is laid down on the words of Article 235. District courts and courts subordinate thereto. It is pointed out that the expression district judge and judges subordinate to him are not used. It is submitted that the incumbents were mentioned control might have meant disciplinary control, but not when the word court is used. Lastly, it is contended condition of service are outside the control emphasized by Article 235 because the condition of service are to be determined by the governor in case of district judge and in case of judges subordinate to the district judge by the rules made by the governor in that behalf after consultation with the State Public Service Commission and with the High Court. Now, we do not accept this construction. The word control is not defined in the Constitution at all. Part so and so which deals with this service under union and they say the word disciplinary control or disciplinary jurisdiction have not at all been used. It is not to be thought that disciplinary jurisdiction or service is not contemplated. In this context, the word control must, in our judgment, include disciplinary jurisdiction. Indeed, the words must be said to be used as a term of art because the civil service classification control, every rule use the word control, and only runs which can be legitimately come under the word control are the disciplinary rules. Further, as we have already shown, the history which lies behind the enactment of these articles indicate that control was vested in the High Court to effectuate a purpose, namely the securing of the independence of the subordinate judiciary, and unless it is imputed disciplinary control, as well the very object would be frustrated. This aid to construction is admissible because to find out the meaning of a law, recourse may legitimately be had to the prior state of the law, the evil sought to be removed and the process by which the law was evolved. The word control, as we have seen, was used for the first time in the Constitution and is accompanied by the word vest, which is a strong word. It shows that the High Court is made the sole custodian of the control over the judiciary. Control, therefore, is not merely the power to arrange the day-to-day working of the court, but contemplates disciplinary jurisdiction over the presiding judge. Article 227 gives the High Court superintendence over these courts and enables the High Court to call for returns, etc. The word control in Article 235 must be in different content. It includes something in addition to mere superintendence. It is control over the conduct and discipline of the judges. This conclusion is further strengthened by two other indications pointing clearly in the same direction. The first is that order of the High Court is made subject to an appeal if so provided in the law regulating the condition of service. And this merely indicates order passing disciplinary duties. Secondly, the words are that the High Court shall deal with the judges, judge in accordance with this rule of service, and the word deal also points to disciplinary and not merely administrative jurisdiction. Article 233 and 35 makes a mention of two distinct powers. The first is power of appointment person, their posting and promotion, and other is power of control. In the case of district judges, appointment of person to be and posting and promotion are to be made by the governor, but the control over district judges of the High Court. We are not impressed by the argument the term used is district judge because the rest of article clearly indicates that the word court is used conveniently to denote not only the courts proper but also the presiding judge. The later part of Article 235 takes of the man who holds the office. In the case of judicial service, subordinate district judge and appointment has to be made by governor in accordance with the rules after consultation with the State Public Service Commission and the High Court, but the power of posting, promotion, grant of leave, and the control of the courts are vested in the High Court. What is vested includes disciplinary jurisdiction. Control is useless if it is not accompanied by disciplinary power. It is not to be expected that the High Court would grant to the government or the governor in every case of indiscipline, however small and which may not even require the punishment of dismissal or removal. This article goes to show that the vesting control of the High Court, the independence of subordinate judiciary was in view. This was partly achieved in the Governor of India's Act, but it was given effect to fully by drafters of so and so. This construction is also in record elected principle of so and so. So now, in this case, what the apex order said that the issue was about the state government, whether it can invoke CCSO. The conclusion is that no, the control of the of Article 235 is there, so it has to be applied, not the CCSO. That's what he said. Further, when 1992, if you are watching now, looks into the judgment of 1992 Force SCC. See, here. Now, what was the case in hand in this, my lord? My lord, this was a case where disciplinary proceeding was initiated against an employee, against one of the employees of the district judge. If your lordship looks into the factual part, where two issues were there after this C kindly one. Lordship, what the issues?
Yes.
Where the High Court on its admissive side had jurisdiction to enhance the penalty imposed by district judge upon a member of ministerial staff of the subordinate court in exercise of power of review conferred by Rule 23 of Gujarat Civil Service Discipline Appeal Rules 1971. 2. Whether the control vested in the High Courts under Article 235 of Constitution exercise only over members of judicial service of the state as defined in Article 236B, or whether the ministerial officer in service on the establishment of subordinate courts are also ultimately subject to such control. So 235, it is not an employee. My lord, I am an employee under district judge. Some disciplinary proceeding has been initiated. So now there is a punishment which is imposed by district judge. It is not that I am control over the state. Any order passed by district judge, it is always applicable to the High Court. That so 235 judicial service that was interpreted by Supreme Court in 236. It includes also ministerial staff. That's what I have understood from the judgment. Now, what is the issue in hand in our case? My lord, the facts is very clear in this issue. There was an advertisement for the post by District Human Rights, and they wanted to be filled up from deputation. So, accordingly, the petitioner who was working, who was controlling authority was the learned CGM, working under as a tester. So now, once the advertisement issued, she wanted to apply. So she applied to the controlling authority. Now the appointing authority district judge. So applied controlling authority with all the particulars forwarded to the district judge, who is my appointing authority. Now the
No, Mr. Das, the facts is not in dispute.
Yes.
And I think you are aware that I am in know of the facts
Yes,
in view of
correct.
my order
Correct,
being
yeah.
passed. The question therefore is, can we say that the district judge out here has the power to send somebody on deputation without due information to the High Court?
My answer immediate answer will be yes. Yes, I will say the district judge has got the power. Even there is 235, because my appointing authority being a district judge. So he has got the power. In absence, now my argument will be, now there is no rule. And that's a 235, the supreme power, control. But there is no rule as such which is framed by the High Court. My respectful submission.
Then tell me, how do you interpret the words vest and control,
Yes.
which is there in Article 235 of the High Court over the district court as well as the subordinate, any court subordinate there too, which includes the ministerial service,
Correct.
where the High Court have no say if the district judge does this.
High Court has a say. I am not saying the High Court doesn't have it.
So if the High Court,
let us
no,
put an example.
Mr. Das, if the High Court has a say out there, and if the High Court has not been consulted prior to giving the whatever has been directed, then in that regard, can it be said that the release order at all has any value?
Then my answer, immediate answer to your lordship's query will be that what I just remembered, that what your lordship's view on that day, that the initial route itself is bad. So we don't go ahead to others part of the issue. So that becomes an illegal. So we can recall. That's if I'm not wrong. That's what, because we have the under 235, it was not consulted with the High Court. Now I give an answer. My immediate reply will be in respect of the particular, the vest and control and the power to recall. Because it was recalled because of the register of the.
No, whether he should have recalled or not is not the question. The first question is whether he could have been at all sent. First, if he cannot be sent without the concurrence of the High Court, remaining all other things goes for a 6.
But my submission will be there. My submission, the district judge being the appointing authority, I have to apply before a district judge only.
Yes.
I cannot apply before the registrar.
No, you are not. You have to apply before the district judge.
Yes.
There is no quarrel. For a leave, you apply before the district judge. The district judge has been given the power to grant you the leave.
Yes.
Everything is there. But can you take out somebody from the service of the subordinate judiciary? Because this will have far-reaching consequences.
Then my immediate answer will be that will not be illegal. That at best it can be irregular, which can be regularized by the High Court. That's my immediate reaction of your lordship's query. Initial route of that particular what your lordship said, that doesn't become an illegal, it becomes an irregular which can be regularized by the High Court. Because there is no rule as such. That the rules has not been framed by the High Court. 235 is there. Yes, can I put an example in this manner? I am an employee of a district judge or a CGM. I have to apply a leave. Being an employee, I apply a leave. So the leave has to be applied before a district and session judge. So it is not necessary, with great respect, the district judge has to send to the High Court and wait till a leave is sanctioned by the High Court. So that controlling authority, appointing authority where I have to apply for leave is only before a district judge. Not before a High Court. So the power which is vested to the district judge is my appointing authority. Where I have applied, it is not a case where an illegal entry was made without any application. The CGM, the controlling authority, he was aware of it. He or she was aware of it.
You mean the Constitution? Constitution, yes.
My lord, he or she was aware of it. It was in district and session judge aware of it. My lord,
district and session judge was aware how?
No, most important, my lord, most important in this case, with great respect, I will say that when on 18/9/2024, when I was released, copy was marked to the register.
Yes. Then only the thing came to light.
No, I just
this is how the things came to light.
Now suppose, my lord, my next argument, first argument will be, it is not an illegal, it is an irregular which can be regularized. That's the first point, my lord. Second point, my appointing authority, district judge, and I applied to a proper format which was advertised. And it was sent by the controlling authority to district and session judge. And district and session judge knew and very well he said, okay, go for the advertisement. And in person to advertisement, selection was made and and my appointment was made.
Where did the district judge allow you?
No, district judge says.
Where?
No, when.
No, show me where.
Yes, I will show you.
Show me.
Yes, I'll show. Okay, watch. I will see. My lord, this is at page. My lord, at page 51. See 51. 51, see a note. This is what approval for participating in the recruitment process. There is a note. Can you see?
Yes.
This I don't know whose handwriting, my lord, whose particular signature, but CGM addressed to district and session judge on the particular.
Does it contain a seal, signature? Can this? No. I'm not concerned to that effect. But can you say this at all to be a district judge's order?
I am to be blamed for that, my lord.
This is not a question of blame. You are.
How I am to be penalized for that?
The question is this.
No.
Now, Mr. Mohanta, is the disciplinary proceedings going on? Mr. Mohanta, is the disciplinary proceedings going on?
Yes, my lord, disciplinary proceeding going on probably in Arunachal, my lord.
Okay. Mr. Mukpatil?
Yes.
The disciplinary, what is the stage of the disciplinary proceedings?
Exact status, I have not got any information, but they appointed CGM as the inquiry officer, as per the record.
They have only appointed an inquiry officer.
Inquiry officer, CGM of the ALO.
Okay. And Mr. Chaudhary, you are appearing for whom?
My lord, I am appearing for respondent number 5, Human Rights Commission.
Okay. Now, what happens if the services of the petitioner is terminated?
My lord, if I may, no, my lord, if we give a correct meaning to Article 235 of the Constitution.
We will go into 235 later on.
Yes.
What happens to the service of the respondent, of the petitioner at your place once the petitioner's service is terminated here?
No, I'm coming to that only, my lord. First of all, my lord.
No, Mr. Chaudhary, the rest I have understood. You answer me that question. What happens to the services at your place? At your place, if the petitioner's service is terminated here?
No, that is an issue which is to be decided, because in my humble submission, whether he or she stands repatriated. Now there is no release order from the borrowing department. Supreme Court says normally this term should be allowed to be completed.
No, Mr. Chaudhary, the borrowing department question will come later on. First, without the concurrence of the High Court, the release has been given by the judge, which he could not have done. That is the issue before this court.
Yes. Now, there I agree. There I agree with your lordship. But my only submission is whether it's a curable defect, whether there can be a post facto approval. There can be no manner of doubt regarding interpretation of Article 235 when we say control and the power vests in the High Court. Let us be very clear about it. She was an officer of the rank of civil judge senior division. Therefore, her release and in fact her NOC ought to have been issued after consulting the High Court. There can be no manner of doubt. I am not on that. But question is, she applied bona fide. Everything was done. It's not a case where any favor has been shown to it. And now give a post approval.
The Gauhati High Court in the principal seat is not providing good internet facilities, Mr. Chaudhary.
I'm trying to get over
No, Well, my humble submission is, it's a case where she should not be submitting proceeding.
No, Mr.
Not done
Chaudhary, I
anything
don't think
wrong
you
for
are
it.
holding the brief for the petitioner.
No, I am holding the brief. Look, we have not
The
even
response
released
number
her.
5. So
The
only,
stand, yes, the
only
stand.
query out here.
This-
You have been
Yes,
brought
I
into
was-
the picture out here, whatever may be.
Yes.
What the petitioner herein has challenged out here is the initiation of disciplinary proceedings and the revocation of the release order.
Yes, correct.
That is the
Now,
act-
in our
you have
affidavit, we have
only
taken a
been
clear
made a
stand.
party. You have been only
Yes.
made a party by the petitioner. Now, I have
Yes.
seen an affidavit wherein your only issue is without the
Yes.
government's concurrence, you cannot
Yes.
remove it. The
Precisely.
question therefore again arises as to
Yes.
whether without the High Court's concurrence, there could have
No.
been all a release being made.
No, that argument I'll not say, my lord. I am with your lordships on that. Yes, High Court should have been consulted.
Mr. Chaudhary, kindly
Yes.
understand one thing.
Yes,
This matter has a lot of importance for another good reason.
I follow. Quite see that.
Now,
I
what
quite
is
agree with your lordship.
No, this is not once, as I could later on learn it, that this is not a one-time issue like this, which is happening in Arunachal Pradesh. In the state of Arunachal Pradesh, what is happening, there are being transfers also being made, which could not
Without-
happen in the state of
without-
Assam. In Kohima, in Mizoram, nothing happens. All
Without
these
concurrence
transfers
of the
are
High
being
Court.
done through the High Court. But this
Correct,
is
correct.
happening. This is a case where the question is, can it be done? Because this has what is doing, I think these people may be a new state for new judiciary out there. For that, they may have been not knowing it. This is being done. The manner in
correct,
which the CGM has done it, or the district judge have done it without taking a concurrence. And in fact, the High Court would not have known if that letter was not marked to the register.
Rest of the internal bench.
It is therefore surprising. So this matter
No.
has a lot of ramifications insofar as the state of Arunachal Pradesh is concerned. District.
No, Milord, I quite see the justification of what has been done by the High Court, Milord. I'm not on that. I'm basically what I'm trying to submit for your lordship's kind consideration is, yes, it is a fact, concurrence of the High Court is a must. I cannot say no to it. But for whatever reason it was not taken, whether, Milord, by laying down the law, lordship can still say that here High Court can give a post facto approval. That is our pleaded case.
But did you apply for that? Have you applied
No,
for
no.
the post facto?
No, Milord, it was basically for the it was basically for the appointing authority, district and session judge, to bring it to the notice of the High Court, Milord.
No, High Court has done it. Now, what has happened is this:
No,
there's
Milord, before releasing,
approval being sought for.
No, before releasing by the appointing authority, that is the district and session judge, this issue ought to have been brought to the notice of the High Court. There is no manner of doubt. I am not saying yes, no to that, Milord. What I am saying is, it was done. Therefore, your lordships will lay down the law. But at the same time, whether the question of post facto approval can be considered. Milord, that is my only case. And secondly, as a borrowing department, we have not, released our AGM. That is the only point that we have
That I
projected.
know you cannot release without the state government's concurrence.
Yes, yes,
I've
Milord.
seen it. But
Yes,
the fact is, first to go to you is the question.
No, my lord, there I have not taken any stand because I cannot argue beyond the pleadings, my lord. But the question of law as posed by your lordship is correct.
No, Mr.
Without
Chaudhary,
consulting.
Mr.
Yes.
Chaudhary, it is like this. If it
Yes.
is any other matter which would have no ramification, this order could have been very well passed.
My lord.
But this will have any order being passed holding that the district judge was right in allowing it.
No.
Then
No.
it will have
That is not my submission, my lord.
It will have
Yes,
far-reaching
that's correct, my lord.
consequences. Means the entire control over the High Court, the Western control under 235 will be eroded.
And my lord, in view of so many judgments of the Supreme Court, now it is too late in the day to question that. The High Court do exercise control, my lord. And the session judge, before releasing, he was duty bound to consult the High Court. That irregularity has happened. That I am not saying no. But only question is, my lord, my submission is whether, in view of the
Yes,
written stand which I have taken in the affidavit,
yes, Mr. Mohanto, what is your stand?
my lord,
No, my lord, your lordship kindly see, my lord, all the record are in the Itanagar branch. But my lord, one thing which is yes, rightly your lordship pointed out is a far-reaching effect that Article 235 that cannot be exercised by the district judiciary, my lord. That is by the district judge. Your lordship kindly say initial order, which was passed by the initial release order itself is wrong, my lord. Itself is bad because your lordship kindly see the 1992 judgment, which already read by Mr. Das, my lord. That 1992 it is very clearly mentioned that it is subordinate officers, subordinate court, my lord, employees are also included under Article 235, my lord. So that's why, my lord, before giving release order, he should have consulted with the High Court. That was not been done. That's why it is apparent. It is admitted, my lord. So since initial, my lord, release order itself is wrong. So, my lord, that's why, my lord, there is some restriction has to be put, my lord, because if your lordship legalize it, my lord, it will be a far-reaching effect, my lord. So my submission before
No, Mr. Mohanto, it is something like this. This release order which have been given by the district judge, or the release order, or the fact that an approval was given by the controlling authority, the CGM, is palpably in violation to Article 235.
My lord.
Yes, sir.
Now, he has asked for a writ in the nature of certiorari for setting aside the revocation order, which I may not exercise in this case. I may not exercise. But one thing you have to also take in mind, that it is not only the employee who is at fault.
Yes.
If you are not taking any action against the district judge or
Exactly.
who have done this,
yes,
then how do you go ahead?
So that will also, my lord.
It look nice for your High Court on the administrative side, that for the judicial officers, they may do anything, but ministerial staff, we are going to be a very high, strong-handed.
Exactly, my lord. That has to be, my lord. But I have to take.
How do you take care of that imbalance? I may very say that, but how do you take care of the imbalance that you have not initiated show cause proceedings or disciplinary proceedings against the district judge or even the CGM who have done it?
Correct.
How do you take care of that?
So, my lord, in that regard, yes, that has to be, my lord. Because they are also at a fault, my lord. Because
you cannot escape that aspect.
Yes, my lord.
Because at the end of the day, the petitioner have asked for two things. One is revocation, challenging the revocation of the release order, which obviously this court would not interfere because of the fact that the release order was right. The second thing, the petitioner is challenging the disciplinary proceedings. Now, once the disciplinary proceedings are there, wherein it is seen that there are actions being taken upon the action of the petitioner is based upon the actions of the judicial officer. Then how do you take care of that situation?
My lord, that I have to consult with my lord, and I have to take instruction on that. My lord, definitely, my lord, some action has to be taken against them also, my lord, because as if they are exercising power 235, my lord, which they cannot, my lord.
Because this needs, you need to file an affidavit on this aspect.
My
because
lord.
This has a lot of, why you have not taken any action against those judicial officers? But you can carry out your disciplinary proceedings against him, and once it is terminated, then we will hear Mr. Kane Chaudhary as to what remains in his deputation job.
My role is limited, Milord. I was only thinking, Milord, that officer is not at fault, Milord. He applied bona fide and she applied before
But
her.
Mr. Chaudhary, you have to also see the replies which that particular officer who the petitioner has given. It appears that she doesn't want to go back only for the reason because her family is out there in Nahal.
Family is in Naharlagun. And well, a judicial officer, she should not.
Instead of that, if she comes back, that is why I asked Mr. Das also. Let her come back, join. Then I can pass some orders to the effect that nothing happens out there. We'll see as regards the deputation out there, something is to be done, and then we can regularize it. But what is happening is, if we don't do anything to that effect, it will have an impact on the administration of justice.
Lordships will kindly grant us little time, Milord. I have also entered only yesterday. Let me also apply my mind, and Milord, we'll get back to your Lordships very shortly. We have taken note of what has fallen from your Lordship just now. Yes. We have taken note of what has fallen from your Lordship just now. Please give us little time, we'll revert back.
If that can be done something. Mr. Mohanto,
My lord.
You are the main person who is involved. You are the vigilance.
My lord.
So you need to file an affidavit and take up that issue as to if the petitioner is released from there and joins, what happens as regards the disciplinary proceedings? Because after all, it appears that the petitioner can be solely not put at fault.
Exactly.
We'll pass an order to that effect, whatever may be. Without the petitioner may be at fault as regards not hearing. Because now with the revocation, the deputation goes again for another problem out there. That is another aspect of the matter. But the question is, if this matter can be solved out in that regard, let her come back, join, and thereafter she applies through proper channel.
Yes.
She can go back.
Then proper way, yes.
But the fact that the petitioner joins would be, but then also, Mr. Chaudhary, it is high time we set the principles right by passing.
Right. Yes.
Because this is otherwise will happen.
Notwithstanding the outcome of this case, Lordship will nevertheless lay down the principles. Yes, that's correct. That is required, Milord.
There are certain guidelines has to be laid down by this court. Because 235
because I think as regards the leave, there is a delegation being given by the High Court to the district judge.
For leave, that's why I put an
That is why it happens. But we are taking out somebody from the service.
My lord, the cadre also, the power has been given by virtue of the rule to the district just to change the cadre.
These rules give many powers. The rules that, just for example, you just go by the Assam subordinate rules of 1987. You will see rule 21 or 19. The power to transfer is being given to the government. This is completely contrary to 35. It is, however, not adhered to. It is all done by the High Court. It's a different thing. But this is how the power is being given.
My lord, subject to what your lordships may say, my impression of thing in this whole case is maybe because of ignorance also few things have been done in this case. It's not that there is any motive or something. In that view of the matter, my lord, lordships will take a holistic view and lordships will get back to your lordships.
No, Mr. Chaudhary, I always try to take a holistic point of view, but the question is, if it can be solved out somehow.
Yes. Now, it has fallen from your lordships, my lord. I'll advise our client, my lord. We'll do, my lord, lordships will give us some little time. We'll revert back to your lordships.
You can very well, once it is being done, if you release that and I get there and she joins, I can still give the liberty
yes.
No, we have then things through proper channel. Then I think
yes.
May be better.
Things can be regularized. Yes.
I think that is the proper way. I have called and discussed. I said that you just think over.
Mr. Chaudhary,
we'll do that.
Today, Mr. Das has come all over to Kohima.
No, of course.
And after coming in a courtroom which doesn't have AC, the temperature has gone up. Heard Mr. D. Das, the learned senior counsel, assisted by so-and-so, appearing on behalf of the petitioner. I've also heard Mr. K. N. Chaudhary, the learned senior counsel, assisted by Mr. S.R. Rava, appearing on behalf of the respondent. 5. First, it is seen from the materials on record that an affidavit has been filed on behalf of the respondent number 5. First, the stand taken in the said affidavit, apart from others, appears to be that without the concurrence of the state government, the borrowing department is not in a position to release the petitioner. First, this court, while hearing the matter, have also inquired with the counsel appearing on behalf of the have also inquired with Mr. T.J. Mohanto, the learned standing counsel of the Gauhati High Court, as to whether any disciplinary proceedings have been initiated against the district judge as well as the CGM, who were also responsible for the purpose of releasing the petitioner without the concurrence of the Gauhati High Court. First, the learned counsel, standing counsel for the Gauhati High Court, submits that he would take instructions in that regard, and also submitted that an affidavit would be filed. First, this court further, an affidavit would be filed on merits as well as on the queries so made. This court have also inquired with Mr. K. N. Chaudhary, the learned senior counsel, as to whether there is a possibility of the Mr. Chaudhary, I would not mention it in my order.
Yes.
Because if I'm mentioning it in the order, it has a ramification.
Milan.
Yes. Okay. Taking into account the affidavit of the respondents, Gauhati High Court would be essential for a further appropriate decision in the matter. This court fixes this matter again when after Bihu.
After Bihu,
on 24th of April.
24.
At the principal seat. 24th of April at the principal seat. So the councils can very well appear before this court in normal mode as well as through RVC.
Deeply.
For admission, item number 11.
Oh, I fixed some matters at 2 o'clock. Which are those matters? What is this? Again, don't come up with the same prayer, madam.
Your Lordship, I'm going to make a listen after.
Why? What is the matter? This is Jagjit Singh. Oh, this judgment has been passed by a division bench. Remember? Where is the judgment? I'm not getting it. Where the scale of pay was sought for? Who was appearing? Oh, that 5-1, 2025, 5-2, 2025. 5-3, nah? Oh, this matter came up yesterday.
No.
Oh, there's another matter, nah? Where is she appearing? That lady out there with the mask. She's, I think, the government counsel? No. She appeared yesterday in one matter, which I fixed it today, I suppose. One matter, I fixed it today. Isn't it? Yesterday, the matter was there. I didn't pass the order taking into account the petitioner counsel would not be there. Same matter, no? Where the government now have taken a decision to grant a scale of pay. So you want an order in your favor or one time?
Your Lordship, at one time.
Why? What can do? You one time, don't time, that hardly matters. We pass as per that order. Give it to me. Let other people also know that you are doing great. Getting an order for your client is a big thing.
The proof of the petition can be considered in light of this.
Same thing, nah?
Light of this.
Huh?
Light of this, Your Lordship.
Yeah,
The
so
case of-
therefore, the case of the petitioner would be considered in terms with this.
In terms of this.
Heard your name,
No.
so and so, appearing on behalf of the petitioner. And Miss Libika, the learned counsel, appearing on behalf of the respondent numbers,
All the respondents.
all the respond numbers 1 to 5. The present petition has been filed by the petitioners, seeking a direction upon the respondent authorities to grant minimum scale of pay to the petitioner on the principle of equal pay for equal work and equal pay for equal work. Ms. Livika, the learned counsel, Livika Visumi, the learned counsel appearing on behalf of the respondent, submits that the government of Nagaland have come up with an office memorandum dated 5/3/2025, whereby directions have been issued to the effect that all work charge and casual employees in all the departments whose names have been duly verified by the district level verification committee and registered in PIMS, receiving fixed pay shall be granted the scale of pay as per the revision of pay 2015 with effect from 1/4/2025.
This process will start only by this month.
Taking into account the said notification being relevant for the purpose of the instant dispute, the said notification bearing AR/LEGAL-5/8/2024 dated 5/3/2025 being relevant is reproduced herein under a notification of in Namo Porpra till the name of the chief secretary. We don't require the names to others. First, no, itu নহয়, itu. Number is different, huh? These are two notifications. The second is for regularization.
Chief, a verification will be conducted.
Will be conducted on the direction of work charge and casual commission. The employees who verified shall be eligible for regularization. This is for regularization.
Yes.
Second, the first one is for that. Huh?
Yeah.
A2 number to the AR-3/GEN-67/2001 dated 5/3/2025 being relevant is reproduced herein under. So a proper government of Nagaland to the chief secretary. Huh? A2, the first one. First of in view of the stand being taken by the government in terms with the office memorandum dated 5/3/2025, it is the opinion of this court that the petitioner's case seeking scale of pay can be very well dealt with in terms with the said above quoted office memorandum dated 5/3/2025. Accordingly, the instant petition stands disposed of, thereby directing the concerned respondents to consider the cases of the petitioner in terms with the office memorandum dated 5/3/2025. With the above, the instant petition stands disposed. You convey. You give a photocopy.
That can be in the record. That can be kept in the record.
The copy of the office memorandum dated so and so 5/3/2025 is kept on record and marked with the letter X. You give a photocopy to me.
Matter.
And your matter, what is your item number?
38.
Same order. Same order. 38. You are also asking for equal pay for equal work, that one, not scale of pay. So it will be disposed of by this same order. 38.
Item number 12.
Mr. Muamchin, one item, I put Mr. Angami's name, you were not there. Remember the home guard?
I went to attend a convention.
Anyways, I'll put your name there instead of Mr. Angami.
Yes,
I have directed, you have already placed one document
correct.
earlier, wherein you said that 2, 3, 4 can be duly considered.
Yes.
So I said the case, consider the case of the petitioner if you have vacancy and if exigency arises. So I have disposed it off. I'll just put your name there. Yes, Mr.
This matter similarly, it is for the lot of cases also.
Same.
Lordship, there's an additional prayer, Lordship. I'm seeing regularization in terms of the office where it is levels 15, Lordship.
You are fixed pay.
It's great.
So you want which order? This second order, this order only.
If I'm eligible, I'll also be considered under the 2015 OA, Lordship. I've completed 33 years of service, Lordship.
Wait. So no, there is another notification.
Oh,
You have seen that.
yes. I've been closing my, actually, reply, Lordship.
This is the 5th of March 2000. The other one is different. This is different.
Lordship.
You are in exercise of the powers under subsection 4 of the Nagaland Work Charge and Casual Employee Regulation Act 2001. The state government of Nagaland hereby notifies that all contingency, fixed and wage paid employees appointed on or before so and so shall be deemed to be casual employees and henceforth come under the work charge and casual commission and shall be eligible for the schemes. So now you will be considered, irrespective whether you have the scale of pay or not. Isn't it?
I got a void.
The earlier OM is for grant of scale of pay, which I have disposed of those two. But this, by this, a person who is in fixed pay now would be given the, would be included as per the 17.3.
Lordship.
Isn't it?
Yes.
So we dispose it on terms with this.
Lordship.
So these have a disastrous, it has a far-reaching change in the litigation scenario in Nagaland now.
Yes.
Huh?
Yes.
60% of the matters will go away.
Yes.
Yeah. Less work for government councils and for petitioner councils. Huh? Most of the matter is because of this. Chalo. Heard Mr. Muajami, the land council appearing on behalf of the petitioner. And how many years of service you have done? When were you appointed?
1991, Lord.
1991. So what was your age?
Because 3 years.
You were 51 when you filed the
Yes,
petition.
Lord.
Then 33 is when you were minor. You are giving employment to minor.
I don't.
Heard Mr. Muajami, the land council appear on behalf of the petitioner. Mr. Muamchin appears on behalf of the respondent numbers 1, 2, and 3. The petitioner herein is aggrieved by the non-consideration of his case, his or her case for regularization and non-grant of the minimum regular pay scale, in spite of having served 31 years since her initial date of appointment. Full. As what?
Labor law, it's paid.
As fixed pay labor. First, it is seen that the petitioner, it is seen from the relief sought for in the instant writ petition that the petitioner seeks a direction from this court that the petitioner's service as fixed pay labor be considered in terms with the office memorandum dated 17/3/2015 and the office memorandum dated 22/9/2004. Further to that, the petitioner have also sought for a direction for payment for pay of the minimum regular pay scale in terms with the latest revision of pay with areas thereon. Hey, bring that X again, the document. Earlier petition, that is why I asked you to make a photocopy. This court finds it very pertinent to take note of that the government of Assam, government of Nagaland, had issued a notification bearing number AR/legal-5/8/2024, dated 5/3/2025, whereby contingency, fixed and wage paid employees were brought within the fold of the casual employees, were brought within the fold of the work charge and casual employees, and was held that they would also be entitled to the benefit of the scheme, more particularly the office memorandum dated 17/3/2015. First, taking into account the importance of the said notification, the same is reproduced hereunder. Ekon beleg de, agohon beleg, ekon beleg. Full stop. This quote upon from the above this quote further finds it also relevant. We bring in the second one also. No, we bring the second one also into this. This quote further finds it relevant to take note of that another office memorandum was issued bearing number AR-3/GEN-67/2001, dated 5/3/2025, whereby all work charge and casual employees in all departments whose names have been duly verified by the district level verification committee and registered in the PIMS, receiving fixed pay shall be granted the scale of pay as per the revision of pay 2015 with effect from 1/4/2025. First, the said office memorandum also being relevant is reproduced hereunder. It will, taking into account the two office memorandum, the details, the contents of which have been already quoted here in above, it is the opinion of this court that the petitioners can case can be disposed of, thereby directing the respondent authorities to consider the case of the petitioner in terms with the said two office memorandums quoted herein above. First, accordingly, the instant petition stands disposed of, thereby directing the respondent authorities, and more particularly whom? The respondent number three, to take effective steps for the purpose of consideration of the case of the petitioner in terms with the above quoted two office memorandums, and the same be done at the earliest. And the same be done preferably within 6 months from the date of a certified copy being placed. I put 3 months is not possible because they have come up days. Do you know how many people will be there? Is it possible? Because wouldn't it be this court? Huh? You want to say 5? Because again, why do you allow another contempt? Okay, 4 months from the date a certified copy of the instant order is served upon the respondent number 3. One application. You have a photocopy? No.
For admission, item number 13.
On behalf of my colleague Thiba, Your Lordship, affidavit is under preparation, so can't be granted on this side.
'21 to 2025. This court have held that this court had perused the order dated 22/1/2021, 28, where large chance was given to the learned government advocate to file the affidavit. It is made clear that if no affidavit is filed on or before the next day, the court shall hear and dispose of the matter on the basis of the materials on record. This is the order. Thereafter, again, you have taken time. 2 weeks.
Your Lordship, the affidavit is under preparation, so if some time can be given.
Hello? We can only allow with a cost of 10,000. Didn't it?
Lordship, we find, and for the private, and only for the private respondent here. Insofar as this is concerned, this petition has been filed in December 2023, and the state has been dragging its feet for this investment. And the state, insofar as my case is concerned, it has nothing to lose, but I have everything to lose because of the stay that was granted.
Shalom, yes, Mr. Something. Let us, somebody, affidavit in the file, well, yeah. Okay, what is your case?
Lordship,
Here,
here, Lordship, here the interim order.
what are you challenging?
Interim order is the, Lordship may come to page 38, Lordship. I shall ask, page 38. Type copy is at page 39, Lordship. Lordship, the relevant portion at page 39, also I'm taking you to the things on report to the type copy, Lordship. The last paragraph. And whereas the issue at hand is not regarding the ownership of the property, as the comments are clear and verified by the then head GB as well as GBs of Toluzuma village in the presence of the undersigned and DDs. But the unsculptured activities of Ms. Srimati so there is estimate 5, who has mortgaged the same plot of land after selling it to estimate 4, Lordship.
Now you are challenging this order.
Lordship, this and the
What is your,
order dated 46, Lordship. Lordship, where, Lordship? Now in the next paragraph, Lordship. I'm about to read, Lordship. Now, therefore, having satisfied myself with all the available documents, facts, and attestations by the concerned stakeholders, including the GBs of the village, the undersigned hereby issued this order that Sri Prelo Kotso, that is the response 4, son of Swanzol, is the sole and rightful owner, Lordship. But the plot during Toluzuma Village Council, Pata number 600 at EKL Toluzuma, and that the GBs of Toluzuma shall immediately remove the signboard placed illegally on the property of Sri Prelo Kotso of Toluzuma Village. This order has been passed by none other than the EAC, Lordship. EAC.
what is the power? What is the power?
Lordship. That is.
What is the power of the
And
EAC?
even the other. Lordship,
You, the building belongs to you.
Lordship, yes.
There are some illegal occupants.
Yes, Lordship.
You want them to be out.
Yes, Lordship.
Who can throw them out?
Lordship. Lordship, what has happened is, I'm just a layman. I am not aware that the EAC is not designated as assistant to DC under the rules, and therefore, so far as my case is concerned, petitioner had occupied my property, and therefore compelled to approach the EAC with my demands and finding merits in my contention. EAC has passed this order, and on the strength of this order, they were asked to vacate the property. But when this order was presented to them, they had approaches on the court on such technical grounds, and therefore it was stayed. And since the date of passing of that order, the property remains to be in possession of the petitioner illegally.
I understand that. I know you are suffering because of this. But how does the EAC have this power? Can the EAC exercise this power? Show me a provision in Nagaland if it is possible.
No. My case is that the prayer may be allowed, I may be permitted to approach the appropriate authority with my demands.
It is the only thing.
Lordship, by vacating the interim orders, Lordship. Because Lordship, this magistrate, the executive magistrate, Lordship, EC is not the authority to decide.
Power can be exercised by whom? Either by the civil court. Where is it? Where is the place?
Civil court and district magistrate as well. As per the
Huh?
City Kima.
And bearing council number so and so. So it can be before DB? No. DB?
Lordship, before the civil court, Lordship.
Before the civil court.
Lordship, no. It can be before the GB also if it is endorsed by the DC.
It is between
DB. Both these avenues are available to the petitioner.
So in fact, what the EAC should have done when he had approached, he should have referred it to the DB.
Lordship.
As per 32, na?
As per 23A.
23A. He should have referred. He himself decided it.
Lordship.
Now, was the EAC empowered to do so? He could not have done that.
Lordship.
23A. So therefore, we have to set aside both these orders and thereby granting you the liberty to approach the appropriate forum.
Either party, Lordship, can enforce the.
You are obviously not going to do it. You are enjoying his property. Yeah. So, madam, you are safe of 10,000. And why you are taking time unnecessarily? You have no business out there. This is an application. I heard Mr. So-and-so, the Learning Council appearing on behalf of the petitioners, and Ms. So-and-so appearing on behalf of the respondent state, and Mr. Respondent numbers 1, 2, and 3. And you are appealing for 4 and 5?
5, it was insert, she was not represented.
Okay, you are appealing for 4.
Yes, madam.
For 4. Full stop. None appears on behalf of the respondent number 5 in spite of service being duly effected. The petitioners herein have assailed the orders dated 22/5/2023 as well as the notice dated 3/8/2023, whereby the respondent number 3 have declared that the respondent number 4 is the owner of the premises, is the sole and the rightful owner of the plot bearing Tola Jauma Village Council Patta number 600 at Khel Tola Jama, and that the GBs of Tolajama shall immediately remove the signboard placed illegally on the private property of the respondent number 4. In addition to that, by the notice dated 3/8/2000, impugned notice dated 3/8/2023, the respondent, the petitioners herein are directed to vacate the plot of the building of the respondent number 4 within 15 days from the date of issuance of the said notice, else the said respondents, petitioners were asked to show cause, as to why action should not be initiated against them for trespassing on private property. First, Mr. Fong said, the Learning Council for the petitioner, Mr. So-and-so, submits that the power so exercised by the respondent number 3 submits that the impugned order and the impugned notice so issued by the respondent number 3 is without authority and jurisdiction. He submits that either the civil court or the authority under the rules of administration of justice and police Nagaland would have adjudicated as regards the right, title, and interest over the plot of land. Full-stop. The EAC had no right to do so. The Learned Council submitted that in terms with rule, isn't it rule or regulation? Section. What do you mention? Section. What do you say? Section, rule, what? Regulation? Rule. In terms of Rule 23A, the EAC ought to have referred the matter to the DB rather than deciding by himself. Isn't it? Of the rules of 37, in terms of the Rule 23A of rules of 37, the EAC ought to have referred the matter to the Dobashi court for a decision. Rather, the EAC himself decided which is not permissible under law. First, neither Miss So-and-so, your name is Angami Oyemi, Miss So-and-so, and the Learning Council appearing on behalf of the respondent numbers 1, 2, and 3, nor Mr. So-and-so appearing on behalf of the respondent number 4 could show before this court that the respondent number 3 had the jurisdiction and authority to pass the impugned order. First, taking into account the above, this court interferes with the impugned order dated 22/5/2023, passed by the respondent number 3, as well as the consequential notice dated 3rd of August 2023, also issued by the respondent number 3. It is, however, observed that the interference so made by this court to the order state or impugned order dated 22/5/2023, as well as the impugned notice dated 3/8/2023, shall not prejudice the respondent number 4 in any proceedings initiated against the petitioner, if so advised. First, with the above, the instant petition stands disposed.
For admission, item number 14.
Lordship, on the request of Mr. Lily, the council petitioner, Lordship, on Monday, Lordship. He has some personal difficulty.
Who?
The council petitioner, Mr. Lily. Has some family obligations, so if to leave for his village. The project may kindly let him after next week, Lordship, Monday, still, Lordship.
You're not there in this matter. It has been submitted by Mr. So-and-so, the learned counsel, that the Mr. So-and-so, Mr. A. Longkumar, who is the person? Mr. Evil Zhao, who is leading the matter, is not available. First, taking into account the above, this is the matter of 2 weeks. In the meantime, the affidavit be in the meantime, the petitioner would be at liberty to file an affidavit in reply.
Item number 15.
Okay. Since the activity is finished, I have sent a letter to the documents. Russian kind and some time.
What is your case, Mr. Lampo?
Here in this case, we should the petition is asking for quashing the appointment of the public respondent and for direction to fill up the post by through a regular selection.
And what about the private respondent?
Should the fax is case. On the page number 36. These are later written by the Procedural director for execution.
Has any affidavit been filed by the private respondent?
This video is scheduled since last year, since the month of June.
Private respondent. I haven't filed yet. My affidavit is ready. However, I'm yet to get a signature. If I may be allowed a week time, Lordship.
Or you resign? Prayer is allowed. she would not have the problem of paying 10,000, the cost which I am going to impose upon the state for not filing the affidavit.
Usually the affidavit is filed also with the winner input the case, but the post was filled up through a selection process. You don't need selection process.
Well, how many papers have been spoiled in passing every time the matter comes up, no affidavit is being filed?
Affidavit is not written. By filing an affidavit of
Which Cheng has been asking for time after time after time after time. So, Gauhati affidavit not filed 25/10, 26/11, 25/1, 18/2, 13/3. We do one thing, we stay the appointment of not to release any funds to the salary to the respondent, private respondent. As you have not filed the affidavit, you are delaying the matter. And tomorrow, if it is set aside, the government is going to lose. Government is public money. So no salary to you. Till an adjourned sign time. You'll be happy, I suppose. No, we impose 10,000 costs upon both the state as well as you. You can't delay like this. You are enjoying an appointment. Show me, Mr. Ringpao, the letter set aside this.
Yes, Professor.
You set aside.
Page 36.
Huh?
Page 36.
36.
Sir,
Go and file appeal.
these are later written by the personal director. Please take on 14 applications for consideration for the appointment.
Application for appointment of Chokidars, MTS at GSC so and so under the establishment.
We should come the second last time.
I am
It is
the,
important.
yes.
It is to be submitted information that the case was forwarded to the DCT for you.
You are reading page 36.
Page 36, last part, second last part.
Let us read from top, madam. Yes, there on the subject cited above and in reference to, you will have the honor to forward with 3 applications along with relevant enclosure for the post of so and so under the establishment of Iman, so and so who voluntarily retired on so and so. 3 names. 3 applications, okay. It is to be mentioned that the case was forwarded from the DC for clarification of land ownership and DC reply stating that the issue of does not arise. The matter is endorsed to the High Court for necessary action. Then what happens?
So that you're denying the later days, we also want to be introduced. Same by the DCT.
Then appointment made.
The appointment made without any selection process.
Huh? No selection. Madam, what is this?
I'm challenging the page number 38 and page number 34. 38 is a approval order, and 39 is a appointment order.
38, no?
38 is a approval order.
And 39.
39 is the
Okay.
interim appointment.
So how did you get appointed? You have already drafted your affidavit. You can tell me.
Lordship, I was appointed to land on it.
That is not the case.
No, Lordship,
This letter is the application, the forwarding of the application makes it clear. The matter is endorsed to the High Court, so and so, stating that the issue of land ownership does not arise. Then
and no proceedings, you can challenge this thing. The cases of the state government, they will not arise. The report is at page number 33. That's one. Page 34, the relevant portion. 34.
the present GSA was established on the land donated by the community. The applicant so and so. What is the name of the applicant? The application of so and so for Chokidar so and so was applied against the retirement vacancy of the landowner claiming against the retirement of so and so claiming of land ownership of the staff quarter located at the old school. However, no agreement or terms of conditions with the government could be produced. The office has already submitted verification of the land to the principal so and so. Since the vacant post which falls under the community donated, the issue of land ownership should not arise. the application of both the applicants. Madam, you file your affidavit. I'm keeping it as part of, we finish up this matter next week. 8. Else 10,000, 10,000. It will be, today was 10,000, so it will be 20, 40,000. What is your salary?
Don't cheat that I'm not well.
No, what is your salary? Oh, you got good money. So it will be 49,000. Okay. So it is seen, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that this court had issued notice on 26, 2024. The respondents have duly appeared. All the respondents and the private respondents have duly appeared on 14/10/2024. Thereupon, time has been taken on 25/10/2024, 26/11/2024, 25/1/2025, 18/2/2025, 13/3/2025. But both the state respondents as well as the private respondent have not filed an affidavit. He submits that this is a case where an appointment has been made in favor of the private respondent number 4 without following the due process. It is a pure and simple case of pick and choose which have been done by the state respondents, which is in violation of Article 14 and 16 of the Constitution. This court, having taken into consideration the above, and also the fact that the respondents have not filed the affidavit in spite of various opportunities being granted, is of the opinion that the matter requires to be disposed of at the earliest, taking into account the submissions, taking into account the materials on record, more particularly the forwarding application of the principal director dated 5/5/2023, wherein it has been mentioned that there is no case, no question arises as regards land ownership. So list this matter on 9th of April 2025, showing it as parted. In the meantime, if the respondents, in the meantime, liberty is given to the respondents to bring on record their stand by filing an affidavit on or before 8th of April 2025.
Item number 16.
The affidavit is under preparation. Moreover, your lordship, state is filing appeal for the division bench. So this case will be covered by the appeal, your lordship.
You're retired?
Yes, Lord.
Ms. So-and-so, appearing on behalf of the state, submits that a final opportunity be granted for filing the affidavit in opposition. First, this is the matter on 19th of May 2025. In the meantime, the respondents are given a final opportunity to bring on record their stand and filing the affidavit. Don't file. Final opportunity I'm giving. You don't file, very good. You give your names, it will be put out there in the order sheet. My order sheet is different. I actually put their names on top. If you see in my order sheet, it is on top the names of all the advocates.
Item numbers 17 and 18.
Please, Your Lordship. Your Lordship, this morning only I have received the affidavit in opposition filed by the state respondent. So kindly allow me to extend.
And so the learned counsel appearing on behalf of the petitioner
Yes.
submits that the affidavit in opposition of the respondent was received only today. So he therefore seeks some time for filing to obtain instruction as to whether they would require whether the petitioners would like to file any affidavit in reply. Lists the matter again on 22nd of May 2025. In the meantime, the petitioner would be at liberty to file their affidavit in reply on or before 16th of May 2025.
I didn't remember 18 and 17. I didn't remember 17, 18. Challenging the same new document order. In item number 17, they have received the file that day. Whereas in my petition supporting the file that day.
Which one?
I didn't remember 18.
Now this is in item number one. Who is 165?
Yes. My learner friend is doing. I didn't know.
Yours is 165?
Yes.
Okay, so that is a separate order. Now your order is what? They have not filed affidavit.
They did not file that day.
You are going to file or rely on the same affidavit?
No, I'm not endorsing this item 18, Your Lordship.
Who is the appearing for the government? You have filed the affidavit? Huh? Why? Oh, I think I need to stay here for some more time.
Your Lordship, in this case, the selection committee was constituted. The selection committee recommended my name. Whereas the private respondent was appointed.
It's okay, but you file your affidavit. When the next date is fixed in the other matter on 21st, na?
Yes.
Okay. The council's appearing on behalf of the respondents seeks for opportunity, a final opportunity to bring on record their stand by filing an affidavit. Full taking into account that the notice was issued as far back as issued more than 7 months ago. This court grants a final opportunity to the respondents to bring on record their stand by filing the affidavit on or before 16th of May 2025. Full stop. The lists the matter accordingly on 22nd question, 22nd.
Item number 19.
One, two, three, four, five, six, 7. 7 leads. No affidavit filed. Hello, we allow her petition. She has been lucky today, having allowing her petition right, left, and center without saying a word. Madam, did you get? You don't know.
I beg your pardon.
You don't know, I suppose. Did you? You were on fixed pay.
So, yes, Lordship. Then they were promoted to scale, Lordship.
Huh?
They were promoted to scale, Lordship.
They were promoted to scale.
Scale.
So therefore, they should have got the benefit under that
But
thing.
if the representation may be disposed of, Lordship, the representation.
No representation. I don't pass that order. So that again, for a retired person to again come and spend money, no. You take your stand clear. Come up with your instructions on the next date. Don't file your affidavit, but you get your instructions. The question of whether these persons can be directed for regularization. Now, more particularly, in view of the 5/3/2025 notification. The 5/3/2025 grants them scale, but this is only with effect from 1/4/2025. So obviously they cannot. They had a scale of pay. If they had a scale of pay, they should have, therefore, be entitled for being considered in terms with clause 3(1)(3). 1 Roman 3 of the office memorandum dated 17/3, isn't it? 1 Roman 3. Yes. The existing scheme for regularization of the Iman against 1 Roman 2 in respect of those workers employees in the scale of who have completed or will complete 30 years of after so and so, their case for regularization will be taken up subsequently in 2 batches as on so and so and so and so. The procedure and terms will be same as laid down in the OM. So therefore, their case should have been taken into consideration if they were in the scale of pay and have already completed 30 years. So when they completed, you should have taken the things. When did they retire? 35 years? This is another important. 35 years was released on 35 years. So they retired on 2017. They had completed 30 years on 2017. One is 2017, the other is of, the other is of 11/10/2020. What were you doing all this while, madam? What were you doing all this while? Well, you get your instructions. Ms. S. Young, the learning counsel appearing on behalf of the respondent submits that she will obtain instructions as to whether the case of the petitioners could have been considered in terms with the office memorandum dated 17/3/2015, taking into account that the petitioners were already granted a scale of pay and further the petitioner had already completed 30 years. After on 30 years prior to their retirement. Puts the list of matter again on, we have it on 10th, 19th.
Item number 20.
Should, the petitioner is challenging the eviction order in one day. Do you before him?
What are you challenging?
It's reflected in the next item. The part junior tentacles, Manor. Before coming to.
No, is there a stay?
Is it?
Stays there.
This matter burden is state. Here a petitioner, he is a dental surgeon. And he has been rendering his services in the Boca since we have 2017.
But Mr. Counsel, your prayer is very limited. How do we, what is your prayer? See, they allow the petitioner to participate in the recruitment process to be held on.
Yes, my lord. His prayer in the petition is that he should be allowed to participate in the special recruitment drive.
So what remains?
But stay is not in that.
So therefore, what remains?
My lord, no.
Your worship, in this case, out of so many doctors, the state respondent has invited for created for 5 posts. So the petitioner, they prayed, they sought prayers to allow them to participate in the
Recruitment process.
recruitment process. But that recruitment process also is already came on, yes.
So it is over.
Yeah, it's over. It came out.
If it is over, then
No.
what remains in the petition?
No, Lordship, no. Those who were appointed during COVID, and those who were appointed prior to COVID also, who were served during the COVID, a special recruitment drive was to be conducted for the certain service they had rendered. Now, Lordship, the petitioner was appointed under election. That is my opinion. I'm correspondent on board. He also served during COVID. His contention is that I should be included because he was not included in the list. So this is the prayer, Lordship. Now, because of the other pending cases, Lordship, there are 2 more pending cases. Filed by the MO, medical officers, some by the private medical graduates, and one by the research scientists. Now, because of those cases, Lordship, and the government has kept the recruitment process in advance because of the objection from the civil society, Lordship, and the student unions. Now, keeping in view of the abeyance order, the court has passed an order saying that the recruitment process should not be done.
No, here the order was different.
If I may, my lord.
This court's order is this, that in view of the notice is issued, advocate so and so, having regard to the projection made by the learner, it is hereby that any regularization made on the basis of the written examination here shall be subject to the outcome.
Yes.
There is no stay.
There's no
So
stay.
there is no stay means unless there is a recruitment process again done,
Yes.
or he does not challenge the recruitment process,
Yes.
how can he get any relief with that relief which is being sought? Mr. Gauhati, you are the main counsel.
Yes. My credit is very limited here.
That is why I
My
am
only query
saying,
is that I may be allowed to participate in the recruitment process. Whenever it is.
but that recruitment process is already done.
That has been
You
stated
see,
by
the order should have been passed on the first day itself, to the effect that you may participate, but any decision against you, if you were appointed, no appointment should be made to you if you are selected without the leave of the court. That should have been the order, at best. Or it should have been rejected altogether. But what has happened is they have allowed the recruitment process to go ahead
Yes,
and have made it subject to outcome. But the
recruitment has-
problem arises out there, how do you make it subject to outcome when third-party rights are going to be created? One,
Certainly, Lordship, 3 more requisitions has been filed by different parties, and recruitment process has been stayed. I stated no recruitment has been done. No recruitment process.
no, are you now, so has the recruitment process been stayed?
It was never done, Lordship. The government kept it in advance because of the complaint from.
So therefore, the recruitment process has not started.
No start, no start.
So therefore, the petitioner's case can be considered.
Lordship, I agree with you, Lordship.
No, either of it.
As far as.
If the recruitment process have not started, as it was stated by the government, the petitioner's case can be considered.
That depends on. this-
No, I'm not saying that I'm directing the consideration, but the petitioner's case still remains.
Yes.
That he can be still called for the interview
No, ultimately-
or participate in the recruitment process.
Ultimately, in those 3 petitions, one group is asking for,
Where is the petition pending?
it is kind of.
Okay, I direct this to be listed along with those. I think then,
Yes,
This case of this,
Huh?
yes, and affidavit has been filed in those 3 cases.
okay. Do you have a number?
Cases for general matters, and the others are for the nurse and legal practices.
No, let me take this petition with that.
Yes, but
So then it will be helpful.
Yes, yes.
You can argue there,
More clarity,
whatever may
yes.
be, huh?
There will be more clarity.
And there will be more because your only problem is because your relief which is being sought is very limited. Once the recruitment process starts, because the order without those repetitions, you don't have any right. Your case is finished because the court permitted the recruitment process to go ahead. So we direct this matter to be listed along with
I don't have to read petition number with me. I can supply.
you supplied.
Otherwise, Lordship, here, prayer, the petitioner prayer, the petition is that they're asking for all about release. Let them allow to participate in the basis across 2024, that example. In the review, which is already given like this. So that is only solitary.
No, therefore, the petitioner's right is there petitioner's case is there that if there is any recruitment process being initiated, he has a right.
Yes.
Now, as that it has been stayed, now therefore, this petition can be tagged along with those
Yes,
where
okay,
Mr. Yangamati can argue.
Yes. Yes, Lord.
Where is the number of the petitions?
I
Mr. M. Mujui, the Learning Council submits that there are 3 petitions so filed, which is pending before this court, wherein the recruitment process have been put to challenge. He further submits that, that in view of the challenge, the government has not proceeded with the recruitment process. Pusto. The list as the instant petition is connected to the is connected, list the present with petition along with WPC number so and so. You give the number. In the meantime, the respondents are at liberty to bring on record their stand by filing the affidavit.
My name is respect for someone who has a study course.
No. You see, all names will be given. You don't have that slip here. What means my orders are different. I always put the name of the petitioner. It's in a different manner. I mean. Provide that. Yes. Your name should be reflected in the cause list. The registry shall also reflect the name of Mr. N. Mujoy as the counsel for the respondent number 4 in the cause list.
Item number 21.
Please, Your Lordship. Lordship, I am on behalf of H.H. Kennedy, my senior. Lordship, my senior is out of station, so if your Lordship may kindly release the matter after 3 weeks to file affidavit in reply.
So you have been removed from service. Okay. The counsel appearing on behalf of the respondent, a petitioner, seeks further time for filing the affidavit in reply. List the matter after four months.
3 weeks, Lordship.
Let's have it after 4 months. List the matter after 4 months. In the meantime, the affidavit in reply may be filed.
Item number 22.
Taking into account that the petitioner have already taken adjournments for filing the affidavit in reply on 2 occasions earlier. List the matter in the month of August 2025. In the meantime, the affidavit be filed. Yes, what is this?
Dr. Biden, for the scripture. I told the answering people on Monday to sign.
Okay,
So,
Mr.
let's take a
Moin, the Learning Council submits that the respondent is to file the affidavit on Monday. Taking into account the above, list the matter again on 24th of April 2025.
Item number 23.
Lordship, I need to receive the Karawas complaints. I can leave within 2 weeks time to file the affidavit.
You are sailing in the same boat in the other matter, not filing affidavit, so you cannot object.
There are for the private son.
Yes.
And the petitioners, they have already able to open up for cases.
Huh?
I
Your file, your respond number 6, na? What is the challenge here? There's a stay? No, is there a stay?
In fact, I'm still working on it. There is a stay, but the stay was granted, the government was directed to find out whether the private resident was already serving in the post. So since the private resident was already serving in the post, there was no stay.
So now you are working.
Yes, I know.
The respondents, the respondent, the Miss AME, AME, the Learning Council, the government advocates seeks for some accommodation for filing the affidavit in opposition. It is seen that on 3 occasions earlier, the state have sought for time. Full stop. Taking into account the above, a last and final opportunity is given to the respondents to bring on record their stand by filing the affidavit. List the matter on 25/2025. Full stop. The respondent state is directed to bring on record to file, is given the final liberty to file the affidavit in opposition by 16th of May 2025. Full stop. It is observed that if the respondents fail to file the affidavit, the instant proceedings shall proceed in absence, proceed on the basis of the materials available on record.
Item number 24.
Yeah, Mr. Lordship. Lordship, this morning I have received an instruction. This is for the conventional appointment.
What?
This matter is for the conventional appointment, and this morning I received an instruction, and the petitioner is in serial number 1, and she is the only person to appoint under the urban municipal department.
So the petitioner will now be appointed when there is a vacancy.
Lordship. Once the vacancy arises, she will be appointed.
Okay. Disposed.
Lordship.
Heard Mr. So-and-so, the Learning Council appearing on behalf of the petitioner, and Mr. So-and-so appearing on behalf of the respondent. First, the petitioner herein has filed the instant writ petition, being aggrieved by the inaction on the part of the respondent authorities in not granting her an appointment on compassionate grounds under the establishment of the Directorate of Municipal Affairs, Nagaland. First off, it is relevant to take note of that the state of Nagaland has an office memorandum dated 17/9/2015, whereby a scheme have been formulated for compassionate appointment for state government employees who die in harness. Full stop. Admittedly, the petitioner's husband had expired while in service, and as such, the petitioner is entitled to be considered. Full stop. Mr. So-and-so, the Learned Counsel appearing on behalf of the respondent state, submits that the petitioner's case have been duly considered, and at present, the petitioner is at serial number 1 in the list so prepared, and in that regard has produced before this court a tentative waiting list for appointment on compassionate grounds under the Directorate of Municipal Affairs, Kohima, wherein the name of the petitioner have been reflected as serial number 1. Mr. So-and-so, the Learned Counsel appearing on behalf of the respondent, further submits that upon any vacancy having arisen, which is specifically assigned to the appointment for compassionate appointment, as per the scheme dated 17/9/2015, the petitioner would be duly appointed. Taking into account the above, nothing further remains in the instant writ petition. Full stop. It is, however, observed that the respondent authorities shall duly consider the case for appointment of the petitioner on compassionate basis, more particularly when the petitioner is at serial number 1 of the tentative waiting list for compassionate ground under the Directorate of Municipal Affairs, Kohima. Full stop. The said documents which have been placed before this court during the course of a hearing is kept on record and marked with the letter X.
Item number 25.
Thank you for mentioning and no President concern your what you call respondents. Where you have file
Who?
your what you which name of your
Where is he? I just met him just now, 2 items before.
no, my lord, in this case, where you have to file affidavit, so.
Tell me there, what you are saying about him? 2 items before he was here.
No, my lord, my senator just left for.
Yes, what is this? Prefer the repetition.
In this case, the petitioner was tried by the summary of summary court martial on the alleged amount of unauthorized actions. When he was imposed a penalty of dismissal of service. Sure, I'm challenging that. The issue is, the impugned dismissal order was passed by the government.
It is Mr. So-and-so appearing on behalf of the respondent state, a respondent union. Submits Union of India, submits that some time is required, further time is required for filing the affidavit in opposition. Stop. This court have duly taken note of that the petitioner has approached this court whereby the petitioner have been dismissed for service by an order dated 1/9/2021. Taking into account, this court also takes note of that no affidavit was filed on 17/2/2025 and 12/3/2025. Taking into account some urgency is being shown by Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, lists the matter again on 27th of May 2025. A final opportunity is being given to the respondents to bring on record their stand by filing the affidavit on or before 21st of May 2025. It is further directed that the respondents shall produce the records before this court on the next day so fixed herein above. We don't ring, we dispose on the basis of materials.
Item number 26.
On the fairness. Yeah, so many matters, tell me.
Motion here the petitioner is seeking for regularization motion. He has completed 30 years of service.
You are asking for regularization. Why you are not being regularized?
Motion to have received the affidavit notification from the state respondent.
Why you have not been regular? You are retired.
No, Lordship. I'll be retiring on 30th of this month. 30th of this month, I'll be retiring.
30.
Lordship.
Why have you approached so late? Why you have approached early? Then also nothing is happening. Now, if 30th, if he's retired, she has already completed. You are on scale of pay. Fixed pay. Scale of pay was given with effect from 17/11/1995. And she was appointed on 1991.
Yes.
She has completed 30 years.
Yes.
So why you are not giving her?
No, Lordship, we have already initiated the process. It has been sent to the as per the office memorandum 2015, Lordship is very aware of it. The department has to compile it and then send it to the PNR and the finance department for approval. Then after that, they cabinet. Your Lordship, we have already initiated the process. I have found affidavit in operation, Your Lordship. The petitioner's name, as per the list, which we have been sent, can be seen as number 1, Your Lordship.
Where?
On my affidavit in opposition.
Oh, yeah.
Your Lordship will find that at page 7.
This one, Singlo,
Yes, my lord.
office peon.
Yes, my lord.
So you are going to do it, nah?
Yes, yes. We have already sent the PNR department for approval, the necessary approval.
Okay. Then What is to be done?
Lordship, it can be disposed of if I'm sure my friend will not be filing the reply.
No, that is okay. But the thing is, how do I pass that order as regards that the retirement, this regularization would be given effect to prior to as on what date are you going to give the regularization effect?
Lordship, the regularization.
Subsequently.
Yes.
But if you delay it, then what happens?
Lordship, there is a procedure. There is a procedure prescribed in the Office Memorandum 2015 itself. That procedure has to be followed, Your Lordship, because they are seeking regularization as per that Office Memorandum only, Your Lordship. Now, that Office Memorandum has prescribed certain procedures, Your Lordship. Following that procedure, the service of the petitioners will be regularized. It may consume some time, Your Lordship, definitely, because it's a lengthy process, Your Lordship. However, having said that also, Your Lordship.
Despite of massive process, now you have come up with another notification where you are bringing everybody else.
Fixed pay. The fixed pay employees, Your
The
Lordship.
fixed, not only fixed, contingency, everybody.
Yes.
Then if you are bringing everybody, then why don't you pass on one order? Anybody appointed
Lordship.
is being regularized
From day one.
from day one. Isn't it? Okay, let me fix this matter on Tuesday.
Lordship.
On that day, I'll pass an order. Let me think how. You see, there is one judgment. Mr. Muajami, there is one judgment of mine where I passed it in your case, whereby I made it very clear that this has to be done in this manner. Remember, I delivered it from the principal seat. You have it?
Yes, sir. Not at the moment, but it's still your case.
So there also I directed in terms of this, where I have dealt with what was the submission of the Advocate General and all. There I directed that this has to be given in such and such manner. So that even if it is retired also, all these things, I've mentioned it out there, you remember. So you bring that judgment on Monday and Tuesday. So I'll pass that order in that manner. So that later on she does not again have to come. The petitioner again need not come. Unless you say coming out, although the government's notification dated 5/3/2025 have really affected the work of culture of the Nagaland High Court. This the matter was upon hearing the matter at length, this court have asked Mr. Muajami, the learned counsel appearing on behalf of, you are the petitioner, no? To place before this court the judgment which was delivered by this court in respect to, in connection with the office memorandum dated 17/3/2015. The council submits that you would produce the same on the next date. So list the matter accordingly. Tuesday fixed query.
All right.
From the supplementary cost list for admission, item number 35.
Yes, what do you want here?
Lordship, I beg your pardon, inadvertently, I gave the government notification in my contempt petition that is still pending. And now I saw that it's not here. 31st.
Yes, tell me.
Oh, it's not this one. Then Lordship, I beg your pardon, Lordship.
No, here was a case that the petitioner's husband retired, no?
Yes, Lordship.
Something happened to the effect.
Yes, expired.
And your case is that he could not have retired as per the Nagaland's Retirement Act, which is 35 years or 60, whichever is earlier, but has to retire as per the this,
Nagaland District Court employs rules,
what is
2017.
60.
Yes, 60.
Otherwise, as per the Nagaland thing is 58.
35 years or 60 years.
So
As
then
per-
both are same.
No. Only
35 years in service and 60 years.
60 years.
And here the petitioner's husband retired why?
He expired on 34/2022.
Then?
He expired.
Then what happened?
Then, Lordship, the impugned order, I have impugned only one order, that is at page 37, annexure I. This was issued by the accounts pension.
So why have we challenged this?
I challenge this because here, it says, as per page 22 of service book, the pay of the incumbent was fixed at rupees 5,100 as on 1/4/2003 and later corrected to rupees 4,815, as a result of which the incumbent has drawn excess.
Oh, excess pay.
Excess pay, yes, and to recover, that was it.
So if you are as per the High Court rules, the District Court rules, then you could only retire at the age of 60.
Yes, Lordship.
The 35 years
Yes,
does not
yes.
come
This
into.
does not apply to me, that is why I came before this honorable board.
Why? Three of you are standing, what is it? You are the accountant general?
Yes.
You are the main problem, tell me.
Also now, the issue of the implementation of the rules.
The rules have been implemented.
Yes, now the state has to adopt that.
The state has nothing to adopt. Once it has been notified, why is the question of state to adopt? Is it ever heard of? No.
One notification.
Yes, what does it say? Where is the Honorable High Court please to transfer the year. No, this is different. This is transferring. We are not concerned with that. But as the rules, as per whether you transfer or not, they come within the ambit of that rules which was notified at that point of time. You can unnotify a notified rule. Is it ever heard of? You can repeal a rule.
The situation of the petitioner's husband, that is the All Nagaland Judicial Ministerial Staff Association, has approached this honorable court, and the COP is still pending.
So what?
So only when the COP is.
No, the COP is for compliance.
Yes.
And in terms with that, you have complied. Now you have the COP is for what? That there is already an order of Justice Sartu
Lordship,
at that point of time.
yes.
So saying that this was withdrawn, taking into account that this aspect was withdrawn, what do you call,
The notification withdrawing
the withdrawal was put to challenge, and the government came up that we have withdrawn the withdrawing of the
Yes.
notification.
yes.
And therefore the court passed that order. Now against that the contempt was filed. But at the date on which the notification has already been given, the rules have already come into place, then how do you take care of it? I think I passed some orders in that earlier matter and asked the. I think this is a case where needs to orders should be passed.
So this matter after the disposal of the COP 15.
Absolutely not necessary.
No, there is one notification that has come out where it says that they withheld the employee's salary also, those who have reached 35 years. 35 years. So recently they have issued one order.
You see, I can pass this order on two ways, if you want. I can apply Rafiq Masih. After a person is dead, you cannot. You cannot go for recovery. We apply Rafiq Masih whitewasher.
Yes.
Or we say that this is, which one do you want? I have two opportunities to give you. to give the relief to the petitioner? Which one?
Lordship, I will place one notification that will clarify everything. My lord.
Not there. What is there? No, whatever may be, there are two ways out. I may go for without troubling you into all these other aspects. I may go into Rafiq Masih and pass an order. Because you have allowed him to work. Why did you allow him to work? You should have known. And after he's dead, now you're stopping the pension.
Yes, that's the reason only, Lordship.
Because Rafiq Masih's judgment, you have been looked into it, makes it very clear that a person who is about to retire also you cannot. Now at the time of person is dead, now you are doing it. The government is, with so much of heart, has come up with that 5/3/2025. And it seems the government is heartless when the case comes of the petitioner. What is it? A widow. Tell me.
Lordship, then can it come up on Tuesday? I mean, or
I don't have a CAV. I think I can make a CAV.
Lordship.
Why do you need a CAV? Mr. Moju, what do you say? Why should I go into that aspect? Let me dispose it of on Rafiq Masih. You've seen the judgment of Rafiq Masih. Let me do it on the basis thereof that you cannot withhold this amount. You have it, 2005 or 11, whatever it may be. Isn't it,
Yes.
Rafiq? You have? Rafiq
Yes,
Masih?
Rafiq, yes, Lordship.
Okay, come to the last paragraph.
Notice 18. It is not possible to postulate all situation of hardship which would govern employees on the issue of recovery where payment have mistakenly been made by the employer in excess and their entitlement. Be that as it may, based on the decision referred to herein above, we may as ready reference summarize the following few situations wherein recovery of the employee would be impermissible in law. One, recovery from the employee belonging to class 3 and class 4 service or group C and group D service. Two, recovery from the retired employees or the employees who are due to retire within 1 year of the order of recovery. Three, recovery from the employee who, when the excess payment has been made for a period in excess of 5 years before the order of the recovery is issued. Recovery in cases where an employee has wrongfully been required to discharge duties of a higher post and has been paid according
No,
to.
we don't want that. B is enough.
Lordship. B.
We go by B. Chalo. Heard. Miss so-and-so, so-and-so, Mr. Can you give your names, huh? You have something to say. Why are you opposing?
I'm agreeing on behalf of the standing council of the Gauhati High Court. So the ordering the person is present.
Who is the Gauhati High Court Standing Council?
It's A is Imam. It's A is Imam.
He is not there.
Your lordship is our station.
So what should I do? Are you opposing the case of the petitioner?
No, your lordship. If the matter may come on Tuesday instead.
No, CAV is done now. Do you have anything to say? Are you opposing the case of the petitioner?
No.
You are not.
Therefore,
They have, what is Mr. Mojo's submission?
As far as we are concerned, we have already written to the state to clarify on the issue.
Clarify.
So,
And the state says what? What is your stand? You have not filed your affidavit.
Ground that the matter will be taken up after the.
No. And are you paying her the pension?
no. It has not processed yet, not even started. Because
So
of this
how
letter,
much should we impose as interest? 9%. 9%, ne? The pension is 9%. Kindly give your names, huh? So and so here, the judgment reserved.
Item number 36.
this yesterday's part of that. So Joshua was asked to appear.
Oh, yes. Mr. Seki was supposed to appear.
Yes, Lordship, but he had to go because he had an official meeting to attend.
Huh?
He had an official meeting to attend.
So then you are going to do it.
Lordship, since I'm looking after the case, it's,
Tell me.
so.
Why
Lordship-
was I supposed to dismiss yesterday, Mr. Mojui?
Because the land has already been compensated and the 2000.
Oh, 3 lakhs.
Yes, the notification says on freely donated land.
Yes. How do you take care of it, madam?
Since
You have already been paid 3 lakhs in the year 1994. And that would have been now 3 crores, huh? You will give you a grade 4 job. You pay back the 3 crores. You are happy, no? With 3 crores and you will give a grade 4. Okay. Done.
But Lordship, even if
You don't have a
then he
case
has-
because the entire clause 3A of the office memorandum is very clear. It says that when it is given free of cost. Now you can, a job under the government can be given on the basis of a scheme. The scheme says that if it is free of cost, if the free of cost element is not there, whatever agreement must be there or not, then you may have to only ask that because that is not the scheme.
So since your Lordship. has
Yesterday I
observed
was
that-
about to dismiss it,
Yes,
but
Lordship.
Mr. Seki said that don't dismiss it in my hands, dismiss it in your hands.
So since your Lordship has observed that this present petition is barred by 3A of the notification, your Lordship may kindly allow me to withdraw this petition and give me the liberty to file afresh so that I can challenge the notification. Because there has also been an oversight on my part also, Lordship.
Huh?
There has been an oversight on my part also.
Sure. Well, withdraw.
I leave it to the petitioner if they want to withdraw.
So
Because
that-
ultimately the interpretation of the clause 3A of the notification will come. Because this is not only for this department, it's for the whole state.
No, this will have an impact. Anyway, she wants to withdraw.
Yes.
The
Withdraw
learning
and file
council
afresh,
is appearing,
Lordship. Withdraw and file afresh, challenging the notification.
The learning council appearing on behalf of the petitioner submits. Then what will happen to all those who have been appointed?
Under the notification.
Huh?
They want to use the notification as a sacrificial lamb.
You may not be able to move around in Nagaland thereafter.
But Lordship, because different yardstick has been applied by the state for this different laws, Lordship.
You see, there cannot be a negative equality. The state may do all wrong, that is for them. But I cannot be a party to their negative equality.
In fact, there was no policy for land ownership appointment. No, except the school education department was following that if you the land donated freely, they give appointment. So this matter was taken up by the principal state, by the chief justice. And a direction was issued to the chief secretary to come up with a policy, and this policy is that this not continued.
Ms. So-and-so, the learned council appearing on behalf of the petitioner submits that taking into account that there would be a requirement of challenging the policy on the basis of which appointments have been made on land ownership basis, she may be permitted to withdraw the instant petition without prejudice to her rights to file a fresh writ petition on the same course of action, along with a challenge to the notification.
Yes, Lordship.
Taking Mr. N. Mujoy, you have nothing?
I'm for the public respondent.
Mr. So-and-so and Mr. So-and-so appearing on behalf of the respondents submits that they have no objection. Taking into account the above, the instant writ petition stands closed on withdrawal, full stop. Liberty given to the petitioner to file a fresh writ petition on the same cause of action, subject only if the petitioner challenges the notification dated so and so. What is the date of the notification?
5th
8th March 2018. Acknowledged, Lordship.
So they have to then, they cannot come up again. Otherwise, the liberty is not there.
Yes.
They can't come up again with the same presentation. You have to come with a challenge. Hearing over? Admission over? How many are there? The time is till 4:45. Although I don't like on a Friday.
Item number 37.
Huh? No. Isn't the time till 4:45? Yeah. The principal seat it is 4:45. Yeah, 4:30. It's the same time, na? Okay. There's a stay of a termination. How is it possible?
Lordship,
Have you ever heard a person being dead and stayed by the High Court?
Lordship, this is a contract issue, Lordship.
Whatever may be, contract issue cannot be stayed. You may at best get what? Compensation.
Lordship.
Then
Lordship.
go before that. How
Lordship,
can there be a stay? It's a contractual work for doing what?
public purpose, public interest, public works, Lordship.
So what work is this?
For construction of, Lordship, officer rest house and
So then,
subordinate rest house.
so you will be entitled to compensation at best.
Lordship.
It's a case of breach of contract.
Lordship.
If there is a termination, it's an illegal termination, you have to file a suit or go for under arbitration.
Lordship.
You cannot file a petition once it is terminated. Before termination, you can come.
Lordship.
But you have come after termination. It is impossible. Can this court pass an order? They will now give it to him. Not possible. No writ can be issued.
Lordship, there has been some developments, Lordship, after the filing of this petition, Lordship. Despite the stay order.
The developments or no developments, the question is there is already a challenge.
Yes,
There
Lordship.
you have been terminated. Matter ends there.
Lordship, in fact, Lordship, I am not pressing the prayer one, Lordship. That is the development that I want to apprise this honorable court, Lordship. The railways, Lordship, they have already engaged another contractor, Lordship, for executing the remaining portion of the work, Lordship. Now, and even as we speak, Lordship, the work is in full swing, Lordship. And the petitioner here, he is the attorney holder, the executor is the provider, they are father and son, Lordship. Unfortunately, Lordship, the father he has been visited with a serious illness, Lordship, which is why the power has been handed over to his son, Lordship. And now he has also made peace with himself that due to his health concerns, Lordship, he'll also not be able to continue with the work, Lordship. So the father, he is still out of station, but the attorney holder, Lordship, he has already reached Nagaland district, Lordship. And we are also intending, Lordship, to meet the officials. And Lordship, because Lordship, the concern is this, not to continue with the work and such, Lordship. However, I have made performance guarantee deposit, Lordship, of more than 52 lakhs. And Lordship,
Mr. Let us not go into all this.
where is money, Lordship?
All these things are there. Is there an arbitration clause? Arbitration clause in the contract?
There, Lordship, there is a clause saying that, Lordship, if any dispute arises, Lordship, the issue shall be decided, Lordship, in the place where the work order was issued.
Where is the contract? Where is the dispute clause? GCC, yeah, provisions for efficient, competent staff, settlement agreement. Arbitration and settlement shall be governed under clause 63 of the Indian standard so and so, which are reproduced below subject to any conditions. So reproduce your deployment document. So 62. So this will has to be go as per this. So if you have anything out there, why don't you demand for arbitration where you are not making it 64.1, page 109? Go there. And once you make the demand, then file an application under section 11. Mr. It seems that I have become a more of an advisor than a judge.
Lordship, I am very thankful, Lordship, to my, for giving those valuable advices, Lordship.
So what you need to do is, taking into account that there is an arbitration clause,
Yes, Lordship.
make a demand
Yes,
and move in section 11.
Lordship, Lordship.
That is the only way you will be entitled to it, because otherwise they will encash your bank guarantee, everything will go.
Yes, Lordship.
So you do whatever what you are doing out here is disastrous thing. The learning council heard this.
Lordship, otherwise, Lordship, there are also decisions, Lordship, which says that Article 226, Lordship, the non-exercise of alternative remedy is a self-restraint imposition by the High Court itself, Lordship.
You see, no, Mr. Counsel, you are not understanding. Your work has been terminated.
Yes, Lordship.
This court cannot give you that relief. Now, if it is a wrongful termination, you go for the purpose of claiming a damage. So therefore, you are asking an arbitration. And when you are asking an arbitration for illegal termination, you ask for amount. You'll be asking for certain amounts.
Yes,
when you are asking for a certain amount, then you have to file a section 11.
Lordship.
When you file an before the district judge, asking for an injunction.
Lordship, then in that case, Lordship.
Section not 11(9).
Lordship, in that case, if it can kindly be listed on 9th, Lordship, before my Lord.
Why?
Lordship, at least allow me to have a sitting with my client tomorrow, Lordship.
No, I'm dismissing it. Which
Yes,
one do you
Lordship,
want?
it's all right, Lordship. Kindly dismiss it on 9th, Lordship. But I have already understood the outcome, Lordship.
Hello. Upon hearing the matter at length, Mr. Santianger, the learned counsel appearing on behalf of the petitioner, seeks another opportunity to obtain some instructions from his client. First, list this matter again on 8th of April 2025.
Before my Lord.
Showing it as part.
Much obliged.
For orders, item number 27.
Oh, no more matters. 445 I will rise, huh? Any orders which have to be extended or anything?
Lordship, here IA was filed, Lordship, for vacation, but it was dismissed, Lordship.
Which one?
Then item 27, Lordship. Now I have received the affidavit in opposition filed by the private respondent last week.
No, Mr. Sanjay. The question is, anybody wants an extension of any interim orders in the orders items? No. Then it will come up on some other day. Get your dates from them, they will give it. I'll sign it. Okay? Whenever you.
My Lord, and if I may be allowed to serve the petition by trustee service upon respondent number 4, Lordship. Service is yet to be completed upon respondent number 4. Which is why.
Which item?
Item 27, Lordship.
Mr. Santianger, the learned counsel appearing on behalf of the petitioner submits that taking into account that the service upon the respondent number 4 is not complete, he may be permitted to take steps by way of dusty upon the respondent number 4. First, taking into account the above, list the matter again on 22nd of May 2025. First, the petitioner is given that the petitioner is directed to take steps upon the respondent number 4 by way of filing an affidavit by way of dusty routed through the registry of this court and file an affidavit of service on or before next day.
Lordship, let the interim continue till the next day.
The interim order passed earlier shall continue. Then we have to put it on today is there, no? What is the date today? 4th. Let us have it on 6th of May. 6th of May. 6th. The interim order passed earlier shall continue till then. Anybody else? Extension? That you get all dates. They will give you. You list the matter and so, just put it. Oh, 6th of, no, 6th of May will be Tuesday.
Pending
You want a date?
Uh,
They'll give you a
Please.
date.